Upgradation.
मतलब interim order expiry.
Extension of interim order, please hand over the slip.
Revision application without certified.
What is the urgency?
My lord, I am the bona fide tenant. I am the bona fide tenant, my lord. I am been dispossessed by the landlady without order of eviction. I am not defaulter on the ground. But when the situation is this, my lord,
When the order was passed.
by 4/6/2026.
So you have to challenge the appeal will lie. If the decree has been passed, our revision will be maintainable.
4/6/2020. The matter is title suit is pending. That title suit filed
When have you applied for the certified copy?
just 1 month ago, my lord.
You have not yet got.
No, my lord.
Have you please annex the yes. Yes, Mr. Vadajaji.
Very compelling circumstances. Prove a matter, today. I am indicating it to your lordship, what is the urgency. This is arising out of an NCLT proceedings. The NCLT has passed an order, directing, corporate resolution of a company.
File it, it will appear tomorrow.
Only thing is, there is leave required for moving without certificate.
Without certificate, you have the server copy.
Yes.
Yes. Yes.
Release, my lord. Release on personal ground.
Release to be mentioned.
My lord, kindly, my lord, the matter fixed on, my lord, 24th August. Any day after 20.
Upgradation,
My lord,
please come
matter,
on Monday.
my lord,
Please come on
kindly see, my lord. Kindly, my lord, matter was before your lordships in the monthly list of July. Now, due to urgency, I have mentioned before code number 6. Matter was there, but ultimately that was not heard. Matter
When
was
the next day.
24th August. Any day
Can
before.
mention on Monday.
No, that I can.
May I be permitted for releasing, my lord? To be mentioned, matter.
Be mentioned.
My lord, may I be permitted to mention a matter? My lord, this is
For what?
My lord, for inclusion.
Inclusion, please come. Inclusion, upgradation, please come on Monday.
My lord, the urgency is that.
Maybe, please come on Monday.
My lord,
Yes.
may I submit? My lord, would kindly indulge me for a minute.
You cannot wait till next Monday.
My lord, the trial court.
I'm asking you, can you not wait till next Monday?
No, my lord, that is the urgency.
Yes, what is the urgency?
The trial court in the matter in the trial court is tomorrow, my lord.
Maybe that cannot be a ground. Yes.
My lord, may I have my lord's kind leave, my lord?
May I mention another matter for upgradation, my lord?
Madam, please come on Monday. The date has been mentioned for mentioning only on Monday. Yes, call the list.
My lord, may I have my lord's kind leave, my lord, to mention, my lord? I am aware, my lord, but just now my lord has said that to come back on Monday, but there is some pressing urgency, my lord. I have monthly list item number 1340. There was
Mr. Banerjee, have you mentioned on Monday?
the previous Monday. No, my lord, I have not mentioned. Some urgency has
Then
cropped
Mr. Banerjee, you have to wait till next Monday. Yes.
My lord. Oblige you, lord.
Well, are you appearing for the opposition?
For release, since I'm not inclined to take up this matter. Since I'm not inclined to
I am for the petition.
yes.
Sir, I am praying for short password because my lord, Mr. Chakraborty is coming, my lord.
Please start. Yes. You are for the petitioner. Yes, what is this matter?
Yes, these are revisional application against
Extension of interim order.
Yeah, actually, your lordship was yet to be heard on that today. It was a trifling matter regarding order 1 rule 10 to allowed by the trial court. That is why your lordship pleased to fix today for hearing of this matter.
Yes.
In a ejectment suit under section 6, learned trial court allowed the order 1 rule 10 to who have no right, title and interest over the scheduled property.
The interim order.
I'm praying for a short passover on the ground of
Extension, no short passover. Yes, who is appearing for the, you are for the petitioner?
I'm instructed, petitioner. Yes, my lord, I'm been instructed. I'm appearing for the petitioner.
You are for, you have been instructed for the petitioner or the opposite party?
For the petitioner, my lord. For the petitioner.
For the petitioner. Pass over next.
I'm for the petitioner. I'm for the opposite party number 2, my lord. Interim order was valid, my lord, till end of July. But thereafter, my junior my lord has mentioned the matter. No copy has.
Application for extension of. Yes, he is saying that.
But,
It has expired, Mr. Mukherjee.
but if my lord will see the last order, it has already fixed for hearing. My lord fixed any date. It can be.
My prayer
both-
also.
Yes, both parties.
Regarding fixing, my lord, no difficulty, my lord, your lordship.
What is this?
My lord, it's, my lord, the point involved is, my lord, while admitting this revisional application, your lordship has framed that whether, my lord, in respect of a easementary right granted in favor of the opposite party, that will disentitle me regarding the title of the property. Easementary only to have access.
The interim order. Next.
Kindly fix the time, my lord, so that it can be.
Yes, call the next matter. Yes.
In this matter, I am for the petition.
Hmm.
Pre-trial amendment was rejected, lordship, during preparation of the chief. It was during preparation of the chief, it was detected like some portion was, lordship, encroached by the defendant. I filed an amendment application that was rejected on the ground, lordship, that that will.
Learned
change the-
advocate appearing for the. Next.
Sir, item 7, my lord, Mr. Devinbach is appearing for appearing
My
for.
lord, I'm appearing other illness, my lord. I'm in little bit late to come. Now, my lord, what happened, my lord, my client has a plenty filed a suit for eviction of a licensee. Now, my lord, in spite of direct 2 times, my lord, written statement have been there, the cost has been imposed, then they also not filed, then so cause, then ultimately filed. Now, ultimately, when the suit was matured for peremptory hearing, they filed an application for amendment of the written statement. Now, my lord, by a written statement, they want to incorporate the counterclaim. There is no explanation why there is a delay. Number 1. Number 2, issue has been framed, evidence started. Now, let's suit for eviction of a licensee. Now they are saying by your counterclaim that there was a verbal agreement. Now, no explanation why this fact has not been brought earlier, and now it is in the evidence stage. Now, there is already a direction is to, as the, there is a delay. By your lordship, the suit be disposed of within 1 year. But
That we are bound, Mr. Mukherjee,
I'm not. This,
where from you are
this
arguing,
ground,
Mr.
this submission-
Mukherjee? Are you in a car?
Yes, madam. There is a late time admitting, madam. There is a late, madam. Due to personal difficulty, there is a late. If you lordship kindly give a password, I can reach by 10 minutes.
Show me the application for amendment.
But kindly see the impugn order. Yes,
Show me
madam. Kindly see the
for
application, madam.
amendment.
I mean, that has been annexed, madam. That is at page.
Now,
Yes.
Mr. Mukherjee, if the cause
Madam,
of
kindly-
action, for filing the written counter claim accrued prior to the filing of,
Kindly see once.
then amendment cannot be allowed, Mr. Mukherjee.
No, my lord, not that, my lord. Kindly see cause of action when arise, my lord. Kindly
I'm
see once
asking
when the
you,
cause of action arise.
when the cause of action
Obviously.
arose.
But kindly see their application. They are
Yes.
saying, my lord, from the beginning,
Yes.
before.
So
Madam,
then it's
may I
within
just,
limitation. If it is within point period of limitation,
may I just say, my lord, but kindly, my lord, but kindly visualize, but no explanation, nothing, my lord. Order 6, Rule 17 provides.
without order 6, rule 17, even they can file the counter claim.
Ma'am, absolutely, Marat, absolutely. But they,
then-
Marat, kindly give me 5 minutes passover. I will bring the. I have already with the judgments, Marat. Kindly give me 5 minutes passover,
All
Marat.
right, pass over 5 minutes. Also bring the contrary judgments. Yes.
5 minutes মধ্যে
Pass
ঢুকতে
over
হবে,
next.
তাড়াতাড়ি করো।
Yes, yes.
The opposite parties let
I
them.
am not challenging the order, Milord, on merits. Milord, I'll be only, Milord, confining myself to, Milord, expeditious disposal of the IA. Milord need not look at the
Expeditious disposal of the
IA pending before DRT, interim application.
DRT. What is the IA for?
Milord, this is from an order passed under section 14. I just indicate. The 13-4 step
Yes.
taken.
So you are the bank.
I'm the secretary. 13-4 step was taken. SA was filed. Then, Milord, in course of pendency, section 14 order was passed. Milord, my learned friend filed an interim application. Milord, challenging, Milord, the section.
That is pending.
No, I tell you, Milord, kindly bear with me, Milord, for a second. Milord, a stay order was passed.
Stay order from taking possession
Yes, by
of
DRT.
section 14.
Yes, by DRT. Milord, we filed a modification application, really, Milord, a review application. Milord, that was also dismissed. So, Milord, stay order and Milord, review order, dismissal order. From both these two orders, Milord, I filed 2 separate appeals before DRAT. DRAT took these appeals together and Milord dismissed our appeals, saying that directing the DRT below, Milord, to dispose of, Milord, the IA from section 14, which is now pending, because Milord, ad interim order was passed. Milord, within 10 weeks.
Within 10
Weeks, Milord, from the date of passing of
that has expired.
that is not 15th September or 14th September, Milord, that timeline would expire. Milord, since Milord, there is an injunction order, I know I can't get a stay, Milord, my learned, and that will, Milord, prolong the proceeding. There is no use of traveling your lordship also. Milord, we had a discussion with Milord, the client also. So, Milord, kindly make the timeline, Milord, given by DRAT peremptory. My learned friend has not used a reply. Let him, Milord, use a reply within a time.
Yes.
My lord, kindly
How soon you will file the reply? Reply,
They
Mr.
have-
Banerjee, you have to file.
No, they have filed opposition.
We have filed IA.
Oh, reply.
What happened? They filed an
You want to file a reply?
Yes, yes.
How soon can you file a reply? Within a week?
2 weeks, 2 weeks, Lordship.
Why?
1
2
week,
weeks?
1 week. Lordship, Lordship,
What is the
one,
next date fixed before the tribunal?
only one thing, Lordship. What had
7th of
7th of August. আজকে কত তারিখ?
7th of August or 7th of September?
August.
7th of August.
Today we are on 6th.
Lordship,
But,
kindly take it by
1
12th
week-
we'll file. By 12th we'll file. Lordship, only one thing, my learned.
Possible can you prepone, Milord?
What is there to file a reply to that
28
objection? Because
crore
your
is like
application is there, you will be only reiterating.
No,
I
what-
think then I can direct the IA to be taken up on 7th.
Yes.
No, Lordship, kindly do not do that. What had happened? They had filed an opposition to my IA. After that, they went to the appeal. We took a plea that cannot be parallel proceedings. When you have submitted,
That's right.
you kindly fix it at
Is
12th.
there anything for which you have to
No,
file
they
a
have
reply?
file a reply because they have brought a
Next,
In fact, Lordship,
you're disposed of. Next.
the next matter.
Sir, well, this order will take care of the other matter because we have two appeals, so two revisional applications.
Next, the
Become
dates will be set.
First in this matter.
In view of the order passed in CO2.
Should be kind enough to serve me copies. They have not served me.
Mr. Banerjee, please solve it.
Have the kindness.
Let him
Yes,
be
call the
rude.
next matter.
Let him be rude.
Kadeen.
For declaration in terms of a
I
partition.
do not have any difficulty in taking up.
Sorry, Lordship, I cannot follow.
Which court?
Baruipur.
Can I take up?
Yes.
This application under
Application is pending, Lordship.
what is the application pending?
Application, Lordship, that has not been mentioned, Lordship. It is for
12/2025 petition dated
Yes,
2/20.
petition.
This application under Article 227 of the
Other 39 rule 1 to Lordship along with the suit, Lordship, 39.
I do not have what? Which court?
Baruipur, same code. No difference.
This application under petition PRSR AI. Last order number 39. Baba,
39. Last matter.
last, yes.
Same person, Lordship, suit up 2020, Lordship, but the injunction application is still pending.
Same court,
Same court, Lordship.
no difficulty.
Lordship, in this matter, Lordship, the SRD has been completed.
It's already completed.
Yes, Lordship.
Injunction is ready for hearing.
Ready for hearing, Lordship.
When it is fixed, this application on Article 20.
A proceeding will under section 26 of the Hindu Marriage Act I applied. So that 22nd is the birthday of my son. I want to 22nd of August. I want to visit on that day my son. That
Who are you?
I am the father. That
You
the
will not take care of your son, Mr. Mukherjee.
it's
On a birthday, you want to meet the child.
even
On other days, you don't want to take care of the child.
it's not that. There are proceeding pending under section 13B that registered as matrimonial suit. In that proceeding, since there is a urgency on 22nd is the birthday of my son, but the learned judge kept it on the day fixed, that is 22nd of September 2026. That will render the application infructuous. May I serve and come back?
When is the birthday?
22nd of August.
How can it be decided before that,
May I
Mr.
come back next week? Next week, any
Contested application? After review.
only yes, I cannot improve that. I cannot improve that, but if your lordship gives me a chance so that
This
I
is
can
only
come
to
back.
put too much pressure on the judicial officers. File, yes, this is
I'm
the
not
thing.
blaming-
Please
I'm
take
not
it up on that date.
I'm not blaming anyone. If it could have been earlier, my client should have been diligent. But today, if your lordship gives us a chance so that I can serve and come back before your
Where
lordship.
is the application?
Yes, my application is at page 27 of my lord's brief. And prayer is at page 29.
Mr. Mukherjee, learned advocate, appealing for the petition as You do not fall within that category once you have got an order of service.
My lord,
Yes.
my lord, I am the plaintiff in the lower court, my lord.
What do you want?
I have filed one application for the my lord injunction along with my lord partition suit.
Expeditious hearing.
Expeditious hearing of the injunction application, my lord. It has served, my lord. They have filed a caveat. We are unable to move the injunction application. Subsequently, it has been served, my lord, on 30th June till pending, my lord, day by day, adjourning, my lord, on last date.
This application under Article 227 of the yes.
The password after all matters.
Yes, yes.
This is
Who is
for,
appearing?
but item 13, my lord, is my revisional application for expeditious disposal of
Of what?
of an application I filed under section 5, read with section 45 of the Arbitration Conciliation Act for reference to arbitration, where they are in the plaintiff is enjoying an ad interim order of injunction which has been extended from time to time. All agreements have been stayed.
What is the next date fixed?
Next date is fixed on 21st of August. Pleadings are completed. Affidavit in opposition, affidavit in reply,
21st of
August one.
No, 21st of August or 24th? No, 21st of
21st. Lordship will look at the order date 3rd of
yes,
July.
21st of August. This application
In this matter, Your Lordship, I am appearing on behalf of the opposite party number 1, Your Lordship,
Yes.
for the Upur Kumar Bose, Your Lordship.
For the petitioner, my lord.
yes, caveat.
No caveat.
No, caveat is there, but Your Lordship, I haven't yet received any copy of the application, Your Lordship.
We will serve and come back tomorrow.
What is this matter?
It is then the leave to appeal the memo of appeal has been rejected by the appellate court. My lord,
Yes.
the order dated 18/6/2025 at page 153, my lord.
the order stating that this principle of amendment will not apply here. Actually the issue is regarding the description of the tenanted premises. The point had been taken by in the written statement. Now in the appeal, that has not been incorporated due to inadvertence. We want to incorporate it by way of a leave under order 41.
Have you sought for leave under order 41 rule 2? Please show me the application that you have sought for leave under order 41 rule 2.
Kindly come to page 136. As well as under section 107, because there are certain documents I found, I want to incorporate that also.
Can it be done? Documents can be annexed to the memorandum of appeal.
No,
Then
that has to be relied upon. That point I
you
have.
can rely upon if it is part of the record, or if it is not part of the record, there are procedures you have to adopt that. By way of this, you cannot add documents to the memorandum.
The power has been given under section 107 of the.
You can bring in new documents.
No, that
You can bring in new documents which are so
document-
the procedures you follow. That's not the procedure. By way of amendment, you cannot incorporate new documents by way of amendment of memorandum of appeal. That's not the procedure.
The documents relied upon.
That you follow the procedures. There are other procedures.
But so far as this amendment is concerned,
Show me the prayer of the application.
page 138.
Yes, what do you say?
In this matter, Your Lordship, I am supporting the impugned order, Your Lordship, as because at this stage they cannot bring in new documents over here. Your Lordship.
Documents. That's he is not now
If
pressing.
if they want
grounds
to,
he can
yes,
raise.
yes.
So I clarify that.
Yes, Your Lordship. But Your Lordship, kindly fix a specific time for the disposal of this appeal, Your Lordship.
Yes.
It's my humble prayer for you.
This application under Article 2
as in the combined list as item number 188. So
For what?
so that is for
Who has filed that? You have filed.
I have.
For what?
That is against the occupational charge imposed by the trial appellate court. So against challenging that order, we have preferred an application that is pending. If that be taken up,
They haven't served us any copy of that
there is
application,
no
Your Lordship.
cabinet. Unless and until it is being admitted.
When that will come up, I will.
Yes, Your
consider.
Lordship.
Yes.
I'm grateful, Your Lordship. I'm grateful.
Sir?
In a suit for divorce, Lord, filed by the wife.
Yes.
Lord, the revision application is directed against two orders. One by way of which my application under section 24 claiming maintenance has been, Lord,
You are the.
I'm the husband.
You want maintenance?
Lord, I had no option. I had no option.
Why did you marry? That option was open to you.
Lord, for marriage, Lord, only
That
love,
option was open to you.
marriage,
But
love
this
is
option is
required.
not open to you.
For marriage, love is required. Now, my lord, my application for my lord, claiming maintenance has been rejected.
Rightly.
And wife's my lord, application for maintenance, my lord, for the child has been allowed.
Rightly.
My lord, against that, I filed a recalling application, a modification application. Lord, that these two have been rejected. My lord, against these two orders, my lord, before your lordship. My lord, my claim is my wife earns, my lord, admittedly 53,000, more than 53,000, admittedly. In 2024, now she earns more. Lord,
Where is the order directing payment of alimony?
Lord,
You are challenging.
kindly, my lord,
Because
first comes
the 18th of May is basically rejection. So the substantive
18th
order
of-
is
18th of May is rejection and also allowing. Two applications were taken, my lord, analogously.
show me the order directing you to pay.
My lord, kindly comes to page. Lord, kindly comes to the first impugned order.
7,500 for the daughter,
Yes.
not for the wife. Mr. Karmukar, you have to pay.
I
For the
don't
daughter. After all,
Lord, I was asking
Maybe.
for Lord, I
Maybe.
was asking for the money. Lord, the wife admittedly earns. Lord, kindly sees the expenses. Kindly sees the.
what is the age of the daughter?
Now she's 20 years old.
Then
Now
what
she's
she is
20
doing?
years old.
What she is doing?
Lord, I was not given a visitation right. Lord,
No, I'm asking you what she is doing now.
studying, Lord, perhaps.
Studying. So, and the father says, I will, she does not need.
Means I do not
Studying in 20 years old, studying in
college, Lord. Lord,
7,500 is not sufficient,
But
Mr.
I
So
do
the
not-
mother is bearing the rest. You have to pay because you are the father.
Lord,
Forget that you are the husband.
may I
Mr. Kormakar, you can forget that you are the husband, but you cannot
let
forget
the-
that you are the father.
This is my expenses towards my daughter. Let the mother bear my expenses. I'll pay for the daughter. Lord, I also have an application.
First, pay for the daughter, then I will consider for your maintenance.
Lord, I have been paying, Lord, somehow this way or the other way. Lord, I have been paying, Lord, about 7,000 rupees for my daughter. Somehow or the other, I've managed. Lord, but more than that, Lord, it's difficult for me.
500, since you can manage 7,000, you can also manage 7,500, Mr.
difficult for
Kormakar.
So the difficulty is, Lord, may I ask this question to myself? Lord, when my application for asking maintenance is on board, Lord, without adjudicating, only one thing is on
That I will
consideration.
consider. First, please pay for the daughter first.
Lord, I have been paying. It's not that I'm
Not
paying.
7,000 at that rate.
Lord, that Lord kindly consider.
No. 500,
Considers
you
that.
can consider your expenses to the extent of 500. Please pay it for the daughter.
I do not have any means. The question of expenses does not arise. Lord, if I would have means, Lord, I would have definitely.
You have means,
Lord,
Mr.
I have-
Kormakar.
I have
You have means to approach this court. You have means to file repeated applications before the trial court.
Lord,
You
these
have
are-
means.
He is an advocate himself, so Lord, he does it out of his own volition. Lord, not volition, but out of his own.
Then
He's an advocate himself. So not that, Lord, lucky. Lord, kindly considers this. Lord, my application for seeking maintenance is on board.
that I will consider, but daughters, Mr.
Lord, but
Kormakar,
that's not been considered.
your maintenance I will consider.
I'm entitled to that.
That I will consider, but
Kindly
not
considers that,
not
Lord.
with regard to the daughter's
Lord,
maintenance.
kindly considers that here and now. Lord. Kindly consider
Cannot.
that.
The opposite party is not here.
At least something I'm entitled.
No. Please serve. Initially you could not get. Thereafter recalling these things. Please. let-
I'll show your lordship two documents. Lord, kindly come.
Mr. Kormokar, you serve. I will consider this, but provided you pay this amount for the daughter. What is the area amount for the daughter?
But area there is.
You have said 7,000
Yes.
and 7,500.
7,500 I'm
So what
paying.
is the areas for the daughter?
That Lord I need to calculate.
Uh,
That's what I need.
Mr. Kormokar, learned advocate.
Lord, if I would have
Studies of your daughter, Mr. Kormokar, the studies of your daughter will be affected. Please pay.
means, Lord,
You have means. You have means.
the maintenance.
You have means, Mr. Kormokar. Yes. Call the next matter. Yes.
I'm for the petitioners in the
Lord, I'm appealing for the
the
opposition.
petitioners are the plaintiffs in the court below, my lord. Against, my lord, dismissal of the misappeal, my lord, which was filed against the rejection of ad interim prayer, my lord, made by the plaintiff, my lord.
Misappeal is against ad interim order of injunction or temporary
Interim order of, I'm sorry, refusal to pass ad interim order of.
refusal to pass an ad interim order of injunction.
Yes.
You have preferred a miscellaneous appeal.
Miscellaneous appeal and an interim order was passed in that, my lord.
Ad interim order of
Yes.
injunction was passed in the miscellaneous
Yes,
appeal.
but by the final order, my lord, the misappeal was dismissed, my lord, based on the documents, my lord, provided by the respondents, my lord. And this I say, my lord, that the scope of the appeal, my lord, the documents.
Why? Bengal Club says it can be done.
But the documents which were not there before the learned trial court below.
There are two views.
And-
In some matters, we'll be relying on Bengal Club. In other matters,
I have brought that one also, my lord.
yes, it says yes, it can be taken note of
One which is
because it was a contested matter.
It's not a.
If some facts have been suppressed and other things, yes, merely because,
Actually, that has happened.
I only.
and more so, you failed to obtain an ad interim order of
Lord,
injunction.
I must have been granted the opportunity to deal with their documents. My lord, kindly
What
consider.
happened? Miscellaneous appeal dismissed.
Yes. My lord, case 38, my lord, the
So what's the stage of the trial court? I am directing the injunction application to be disposed of.
But that has been
that
directed
has
by
been
the.
done, my lord, but
Yes,
kindly
that has been
consider
directed. What is the next date fixed
to inquire, my lord.
in the trial court?
To inquire,
Perhaps, Lord, it has been. May I?
Yes, what do you say?
But considering based on the documents, my lord, relied on by the respondents, my lord, I am yet to, my lord, make my comment on those documents, my lord. Kindly consider.
Next comment, I can consider that here.
Lord, that documents have not been even provided to me. Kindly consider. At the time of
All right,
hearing,
let me see. If you want to go on merits, then I will
at
consider
the
it
time
on
of,
merits.
kindly consider. At the time of argument, they,
Or I leave it for the trial court to decide on the injunction
that my
application.
lord, that my lord will do, my lord. Kindly considers, my lord. At the time of
If you
hearing,
want, I will go into the merits. That's up to you. But after making submissions, don't say now I want to go back.
I'm on the scope, my lord. Kindly
All right.
considers.
All right, make your submission. Let me see.
My lord, kindly
Yes.
considers, my lord, that at the time of argument, my lord,
They have relied on several documents, my lord, which I deny, my lord. I have not given opportunity to deal with them. I have not been provided with those
All right,
documents.
please show me the plaint first.
At page 10, Your Lordship.
I am only on the scope, my lord.
Yes, I will be only on the scope, restricting on the plaint, injunction application, documents filed along with the injunction application. This much I can look into.
Yes, my lord.
All right, start.
Page 10, my lord, is the plaint, my lord. My lord, plaintiff number 1 happens to be the developer. Plaintiff number 2 happens to be the owner.
Plaintiff number 1, developer 2 is the owner. All right.
The owner. My lord, the entire scheduled property is Schedule A. Now, my lord, the defendants, my lord, are, my lord, the owner's daughter and daughter-in-law.
Defendants are the
Owners, means plaintiff number 2's daughter and daughter-in-law.
daughter and daughter-in-law.
Yes.
Mother-in-law and the daughter-in-law.
Yes.
Why are you
Now, my
not?
lord, may I only, sir?
Yes.
Now they are occupying a portion of the property, the entire Schedule A property. They have previously filed a suit claiming ownership over that. That has been dismissed, my lord, as Order 7 Rule 11 was filed by the owner, my lord. After one appeal was filed, that has been dismissed, my lord. They have not filed any further appeal. My lord, my case is that they are occupying one portion of the A schedule property, which I have demarcated as B schedule property. And I have prayed for injunction over the C schedule property, saying that they are trying to.
What is C?
C is the remaining of A.
Oh, A is the entirety.
A is the entirety. B
B,
is occupied by them.
defendant is occupying B.
Yes.
C is the balance.
The vacant land.
Yes.
I have prayed for only, my lord, C schedule properties, my lord, injunction, my lord, that kindly restrain them from encroaching that C schedule property.
Please show me the prayers in the plaint.
Prayers in the plaint, my lord, is at page 13, my lord.
Page
13.
13.
A is the plaintiff number 2 is the owner of A schedule property and executed registered development agreement and power of attorney in favor of the plaintiff number 1. B, decree for further declaration that the defendants have no right to interfere in the possession of the plaintiffs with respect to C schedule property. And after permanent injunction, or restraining the defendants from interfering with the possession of the plaintiffs in respect of C schedule property. Well, kindly sees the after scheduled property. There are 3 scheduled properties. A is the entire property. B, occupied by them, my lord. C, my lord, is the property, my lord, which has been left out of A. Now, Lord, kindly takes up my injunction application prayer, my lord. This is at page 20, my lord, to pass an order of temporary ad interim injunction restraining the defendants from interfering the possession of the plaintiff in respect of C schedule property. Now, Lord, kindly takes up the order of the learned trial court, which is at page 25, my lord. Takes up page 26. Page 26, last, my lord, paragraph, my lord. The court has said that since I could not.
Ad interim refused.
Yes.
All right. Then please take me to
my lord, I filed an appeal, my lord. Kindly takes up the first order passed in the appeal, page 38, my lord. The learned district judge has passed an order, my lord, restraining them from encroaching upon or dispossessing the appellants from the C schedule property. This ad interim order, my lord, continued thereafter for a year. After, my lord, they appeared, my lord, they filed a written objection, which is at page 42. They filed a written objection thereafter, my lord. Page 40. Kindly takes up, my lord, page 45 once, my lord. Paragraph 14. They are saying, my lord, their status over the suit, the C schedule property. Kindly takes up that is stated by these answering defendants, respondents.
Page?
My lord, page 45, paragraph 14.
45, paragraph
14.
Yes.
Stated by these answering respondents, defendants, that prior to the alleged purchase of A schedule property by the plaintiff number 2 of this suit, these answering defendants were in the suit property as it was a barren one, and with the help of local club members, which Belur Songoshi, they took the possession over the suit property and started enjoying the same along with the. Similar, they are not claiming that they are either owners or. And after they have said that they have paid some money and all, on the basis of which they have filed a suit in 2015, which got dismissed, my lord. Based on these facts, they filed the suit in 2015 claiming ownership over the property. That suit got rejected, my lord. In terms of Order 7, Rule 11, my lord, they filed an appeal. That appeal also got dismissed.
Have you executed a deed of gift?
That I am not. I'm not aware.
You are not aware?
Yes, I'm not aware.
Have you filed any affidavit against this written objection?
No, the document may only say.
Suppression. If that is suppression, this document can be taken note of.
Not before, my lord. Before, my lord.
That's one thing. So, are you denying this is a registered deed? You have to say yes or no. And this is of 2022. You have filed a suit on 2025. Then you do not have any cause of action to file the suit.
But this.
You are not the owner.
I have not been. My lord, I have not been even given this document also. I do not know this document.
Registered deed you have gifted, you do not know.
Yes.
Constructive knowledge. File an affidavit that you do not know.
But I have not been even provided
Yes,
the document.
written objection has been filed. You have to make a specific case. Have you denied that in the civil division application? What have you stated about this deed of gift? Please show me.
There is no specific.
Sir, if you want, I will go into those.
But kindly consider.
You have not denied. That was suppressed. By suppressing the fact, you are not the owner and you have filed a suit.
Kindly consider one.
And by suppressing, you have obtained an ad interim order of
The
injunction.
development agreement, payment of money and all. And my lord, these.
No, not payment of money. This deed of gift executed by your client. Are you denying that?
But I'm yet to, my lord, go through the deed, my lord. I do not know, my lord, what is the scheduled property inside that deed. My lord, kindly consider.
Yes, yes. Do you have a copy of the deed of gift?
Yes, sir.
Please show it to him. I fix it tomorrow.
Kindly consider.
No, not consider. Please take it back.
Relationships.
Yes, yes, I am directing him to give a copy. Please take instructions.
I don't have a Xerox copy with now. I have.
Xerox copy, please show it to him.
The relationship between the plaintiffs and defendants. But the mother-in-law, daughter-in-law and daughter are the defendants. Now, my lord,
You are filing a suit as an owner. Let me see whether at the date of filing of the suit you are the owner or not. If you are not the owner, gone. And by suppressing that fact, you have filed the suit, obtained an order of injunction.
yes,
Yes.
by the district judge.
Yes. Please give a copy, take instructions. That's one. Second is, I've gone through the schedule of those properties. A is the entirety.
Yes.
B is only the constructed area.
Yes.
C is the balance.
Yes.
There is no passage adjacent to B. So they have to utilize the balance portion of C as an easementary right.
Get full Roshan.
So on that ground also you are gone. No order of injunction can be passed.
Has to be considered by the learned trial court.
I will consider it here and now.
The injunction.
In injunction,
Kindly
on your plaint and injunction, nothing more than that from the scheduled property.
considers one thing, the application is itself pending for consideration, my lord, on affidavits, my lord, by the parties.
Yes,
my
your
lord.
lordship.
Then I please go back to the trial court. That's one thing. If you invite on the plaint and the injunction,
I only go to the
Entire
scheduled property.
property
yes,
has been
please
sold
look
out.
at the scheduled property.
By the
You can
mother
take
to the
instructions from your client and come back.
The entire property has been sold out, my lord, by that, my lord.
A,
Sold out.
entire A.
Yeah.
Yes. Your client knows. Written objection has been filed and your client does not know.
All that I had 5 cutter.
Entire test. Puro জমিটা
We dismiss the suit here and now. Ownership right from the document itself, it shows that you do not have any right.
is why your lordship.
Order 7, Rule 11 at any stage.
That is why the learned trial court has dismissed the interim order, refusing the interim order in the ex parte. That was the
Now his Order 7, Rule 11 will be allowed. Your Order 7, Rule 11 has been allowed now. His Order 7, Rule 11 will be allowed now.
But from the deed, it appears that
Then,
the entire schedule.
and that's prior in point of time that you are filing the suit. So you have suppressed. You cannot say that I do not know. Where is Bengal Club? That's the decision on that point. If there is a suppression, it can be looked into. I think it's AIR 2003 Calcutta, Mr. Mahato.
না বেঙ্গল ক্লাবটা আনিনি বেঙ্গল ক্লাবটা জানি আমি
Bengal Club he has not brought.
বেঙ্গল no Bengal I am aware of the Bengal club
2003 Calcutta.
yes that's the division bench judge
So Bengal Club is against you. There it says if there is suppression, documents at the ad interim in an appeal against an ad interim order of injunction can be looked into. Yes, now what do you want?
even this one thing even this deed of gift but does not in
Sir,
any way
now-
benefit them kindly consider that they do not have any right over the scheduled property
You do not have any right to, whether they have any right to do, it's neither here nor there. Whether you can make out your prima facie case on the basis of this, that will be considered. If you do not have any prima facie case, you are not attached to any order of injunction. Whether what they have, I will not go into that. The question is whether you have made out a prima facie case or not.
That is the observation of the learned, both the courts.
no not
That's the observation. Please show me.
not both the
Prima
courts
facie.
below by
Yes.
the
Till now, I am giving you option. After I look into that, that will be gone.
real kindly fixes the time period allow me to
After this, you have wasted 10 minutes of time. After some argument. Any cost for this delay of 10 minutes?
No, Lord. Don't impose cost without his price.
Yes, next.
Subsequently, I have been dispossessed. I filed for recovery of
You have been dispossessed.
for recovery of I have filed.
Dispossessed, what's the relation between you and the defendant? You are the plaintiff. Yes, what's the relation between you and the defendant? They have dispossessed adjacent owner or what? How they could dispossess? Adjacent owner. So they have encroached totally upon your property. It's a vacant land. Now what happened?
By the impugned
Injunction.
By the impugned order, my evidence has been closed.
How many adjournments you have taken, Mr. Mark?
I have stated paragraph 5 onwards in the petition. I have consulted the entire order sheet.
How many? I am asking you. How many? Only 3, 4. When the suit was fixed,
17,
no.
19 issue
When
of
the suit was fixed for evidence.
19, my lord, the issue was framed.
From no, issues are framed on 2019. Then first date for evidence of filing of the affidavit in chief by PW1 What? 2019. Today we are in 2026. So 7 years. You mean to say only two thirds?
I have taken the adjournments. Hajira was filed, date has been fixed on the same day.
Some resolution of the bar association.
Because of COVID, all these are there. The opposite party is also taken back. I have stated,
What happened by this? What happened? Your evidence closed.
Yes. And my DW evidence has been.
How many witnesses you have?
How many?
Then cost is to be assessed on that.
That is on the next day. That will be assessed on the next.
Yes, I will mention this here. I will be putting you to notice on that. How many witnesses? Because after one witness is allowed, you will come with 3 list of witnesses, 4 witnesses. So let me see how much time we will take. For that, cost will be fixed. Because now it's the defendant's witness has been, it's defendant's evidence. So it will be delayed by the number of witnesses you will be citing. So that is to be ascertained now.
See that. I have already got the decree of declaration. If you lordships kindly consider.
So Mahato, how many witnesses you have?
I have not that. But it's not more than 2 or 3.
Not more than 2 or 3. So per witness, how much? Per witness, how much? 10,000 per witness. So 3 witness, 30,000. If you are willing to pay.
That should be assessed on the next day.
That way I will be recording in this order. Ashwin, by the order And Mr. Mahato, please take instructions. ওটাকে 8 weeks করছি 6 weeks করে দিন motion 6 weeks. Please take instructions. How many witnesses? Because that will be the guiding factor for assessment of the. Yes, next.
This matter for transfer of on matrimonial suit matter from
Transfer. Section 24.
No, this is 227. We are challenging the order.
Section 24 rejected.
But what am I tell you, Lord Madam? The wife filed a.
On what ground, Mr. Bhattacharya, transfer was sought for?
Brother,
This is a matrimonial suit.
yes. My lord, on the date of reconciliation, my lord, we have tried to file an application for amendment of the written statement because, my lord, we have been acquitted from one criminal case of 498A. Court didn't allow me to file written statement. And on the day, the wife told that I can settle the matter on mutually, subject to payment of 6 lakhs. My father is suffering from cancer. Mother is also suffering from.
So, what is the ground for transfer?
Is that, my lord, court says that if you do not get this matter settled by paying 6 lakhs, take loan from the bank, get it settled. Very meager amount she is saying. I told that my father, my parents are suffering a lot. It is not possible for me to bear. We are paying the maintenance every day. Now, my lord, on this ground, court says I have quoted in my application, if you logically have a look to that, that rather I have been put judicial threat. That I shall pass such an order.
Bhattacharya, can it be a ground for transfer?
Because, sir, because my lord, kindly, I am afraid that I may not get proper. Only
That
I
is
am not
at the.
asking for transfer from another court. I am asking transfer of the matter from that court to
Mr.
of the same
Bhattacharya,
district.
that's at times it might have appeared to the presiding officer that the amount which the wife claimed was reasonable, so it can be sorted out. So
But
for
no,
that,
I had not been
can it
allowed
be
to.
said that you will not get justice? Can that be a ground,
No, I
Mr.
had
Bhattacharya?
not been allowed to file my amendment application. On the day, that is my specific case, I have pleaded. If your lordship kindly takes up my application before the court, if your lordship come to my lord page, last annexure kindly sees my lord. Kindly my lord come to page last.
Mr. Bhattacharya, the order was reconciliation was before the district judge.
No, before the eighth additional district judge.
Before the
eighth additional district judge Barasat. And the impugned order is passed by the learned district judge because.
No, that's section 24.
24, yes. Now, if your lordship kindly takes up my lord, what the learned court, in fact.
The 8th ADJ is still there.
Yes. Yes. Well, any court of that same judgeship, we are asking not that instead of 8th court, it can be 4th court, 7th court, 6th court, any court.
That's one thing, Mr.
Well, your lordship know the Supreme Court in 1987, one large judgment was there. Your lordship see, if your lordship my lord takes up the judgment, yeah, Supreme Court.
Mr. Bhattacharya, judgments are this way and that way also.
My lord, kindly appreciate one thing, my lord. Here is a specific case I have pleaded.
Judgments also, it says the court should be very slow on these allegations to transfer.
No,
because
only I am making such a such kind of aspersion against me, my lord. I have been non-suited. My not allowing me to file amendment application. Well, that is my statutory. How court can stop me to file amendment application, my lord? That is my specific case here. And on
is directed to
this is an inequitous payment. Had it been a case where I am asking for transfer from that court to another district judge, then could have some. Well, I have no intention to, my lord, drag the matter anywhere.
the order rejecting the prayer. What is the next date fixed?
Give me 5 minutes. August, my lord. 14th August, my lord.
14th of August. List this matter.
Defendant is the petitioner, lordship. The plaintiff filed a suit and lordship obtaining injunction with the allegation that I am making construction over the lordship suit plot. Now, injunction order was
Precious hearing.
only in respect of the 151 application filed by us, because on lordship 17th of March, the plaintiff himself, in violation of the order of injunction, lordship started to make construction. I have lordship lost general diary before the police authority and several authorities also. Thereafter, lordship filed an 151 application that has not been taken up for consideration.
This
Lordship
application under Article 2.
It's an order of military. Oh.
Yes.
The order has directed me to my deposit.
Matter, my lord, may I, with the kind permission of my learned senior friend, seek for a my lord, indulgence that this might be fixed on any day, my lord. These 15 volumes, this runs into 15 volumes. Yes, I was provided sufficient time, my lord, to go through. The matter was served on 31st, but there are 15 volumes, and my lord, this is coming out as my
There
lord,
are?
There are 15 volumes to this.
Mr. Shah, why?
Issue is very short, my lord. I don't know, my lord, arbitral records have been annexed. My lord, this is, my lord, an order passed in a section 36, my lord, 3 petition. Our prayer was for unconditional stay, my lord, on good grounds. But, my lord, ultimately.
That has been rejected.
Rejected, but, my lord, without discussing, my lord, here, contrary to the contract, contrary to, my lord, settled provisions of law.
Or when do you want?
Any day, as your lordship wishes, my lord.
I leave it to your lordship. We'll come back.
Tuesday, if you, my lord, there is one thing I must fairly also submit. Now, there is an execution proceeding which is pending, and it is fixed on Monday, 12th of this month.
This Monday?
Yes, my lord, I undertake that no steps will be taken. But if your lordship pleases to fix it on Tuesday, my lord, or any day thereafter, my lord.
Whenever.
Only Monday.
You have got the copy.
I have got the copy, yes.
Uh,
So deeply obliged, my lord, so deeply obliged.
yes.
Hey, নামটা দে।
So the petitioner is the husband, lordship. It's against an order under section 24 of the Hindu Marriage Act, lordship.
What is this?
So I was directed to pay 25,000 per month towards maintenance and 30,000 towards litigation cost. Lordship,
Alimony.
lordship,
Why so
lordship, the
voluminous?
entire affidavit of assets and liabilities was there before the learned judge. And from that affidavit of assets and liabilities, lordship, the impugned order is 6th of May 2026. Now, what we had indicated to the learned judge was that the wife had infusion of credits into her account on every month. We had served interrogatories to her regarding those funds. She has claimed that she has no source of income. Without considering that, lordship, an amount has been passed. If I may just take your lordship to a few of the account statements.
What are you doing?
Lordship, I am a businessman. I run a play school. I run a play school, lordship.
What is your monthly income?
Lordship, my monthly income indicated in the affidavit of assets and liabilities after my business expenses is 40,000. Lordship may have a look at her account. She is for a particular day, on even a date, she has income of 2 lakh rupees.
There's a child.
No, no, no child.
By education expenses, it says
Education expenses, my income has been,
escalating cost of education.
my income has been presumed because I'm a business owner running a play school. Therefore, my income
That cost of education. Oh,
now my entire income tax return along with bank statements were there before the court. So there was no reason to presume my income. Okay, may I indicate three things to your lordship?
yes.
Lordship, first of all, lordship, the bank statement of the wife. For example, in the month of March, she had a credit of rupees 3,89,000. From the period of January 23 to May 24, she had a credit of 19,60,000. That is on one account. We served interrogatories to her regarding would you disclose the source of the income? She responded no. Despite that, the judge considered that ignored my payments under 125. I'm already directed to pay 12,000 as per the interim order under 125 application. I have ailing parents to maintain. She has refused to disclose her source of income from her bank statement. I have been directed on the presumption that I am running a play school. I will be enjoying good profits, that you pay 25,000 and 30,000 towards litigation cost. My income tax returns were there before the court. My bank statements were there. Documents from creditors where my loans are outstanding, even those were part of my affidavit of assets and liabilities. None of that was considered.
The learned advocate appearing for the petitioners. I'm coming after 5 minutes.
That is, my lord, I have already, he was granted, my lord, but these are server copy, my lord,
What is the server copy? Not server copy. Where is the order copy of the server? Only dates will not do.
my lord, only, they are giving only dates,
No,
my
no,
lord.
no.
Only date, my lord.
Please then obtain the certified copy, then file. With that, it cannot be. 24, yes.
The 24 minute I am for the petitioner. My client filed a suit for eviction. Now that suit has been decreed. Now ultimately they preferred an appeal. Appeal dismissed.
Appeal dismissed.
Appeal dismissed.
Now execution.
Second appeal filed, but no steps has been taken, only pending. Now, my lord, when we filed execution, case was proceeding. Now, my lord, then they filed section 47, but did not deliberately move any stay application. Now, my lord, in the execution case, we filed an application that as there is no order of stay, we showed the judgment, proceed. By the impugned order, learned trial judge says executing court says that in order to avoid multiplicity of proceeding till the hearing of those matters, my application has been turned down.
Of those matters with second appeal.
Second appeal and section 47.
Rightly, Mr.
Mama, kindly pass an order so that we can produce before your lordship next time. Kindly see the impugned order next page. Hard peruse considered. If
Next.
Last page of the order.
Last page.
Of the order. Order date, order number.
Yes, yes.
Hard peruse considered. That
the order dated 14th of July 2026.
July 2026.
Yes.
I read from the first. Today is
all right. Yes.
Hard peruse considered. The decree holder has filed the title execution case for execution of the judgment and decree passed in connection with title suit 949 of 2016. It also appears from the case record the judgment debtor has entered appearance in the title execution proceeding has filed an application under section 47 of the CPC registered as miss case number 218/25, which is pending before this court. Though there are raised.
Mr. Mukherjee, section 47 is to be disposed of first.
But in section 47, kindly see so cause.
But that has to be disposed of first. I am directing the section 47 to be disposed of.
Section 47 within certain time. And my lord, if
section 47 within certain time, second appeal within certain time, execution within certain
second
time.
appeal, my lord, your lordship, what we little know, second appeal, my division means, but
cannot be passed.
But kindly visualize the suit was filed initially in 2000. Now 26 years has been passed. Now, if this order stands, my lord, kindly visualize. I will show this order before the lordship court because my lord, the court says multiplicity of proceedings. Section 47, kindly see their conduct, so cause. Every time when the section 47 fixed for hearing, they are not appearing, court issued so cause.
Mr. Mukherjee, learned advocate appearing
Judges are coming. Kindly change it, kindly direct.
You have information, Mr. Mukherjee.
Everyone knows that. Everyone is giving the congratulations. Kindly change. Kindly do that. Otherwise,
তাহলে আগেরটাই করে দিন। That order you taught me.
kindly. This is my fault. Kindly.
Service.
Disposal of the plot.
Of what?
Application for investor application as well as a counter claim. Last order.
Counter claim.
Filed by the defendant.
Counter claim is the suit. How can it be disposed of?
Application filed by the defendant in respect of the injunction petition and as well as suit also. And I filed an application for written statement. Last order.
For written statement by the plaintiff. So you have to file the written statement. File the written statement. This application under Article 2.
Application for expeditious hearing, Lordship. The title suit was filed by the petitioner, Lordship, in 2023 against the respondents for eviction, Lordship. Thereafter, Lordship, the defendants.
Yes, who are the learned advocates appearing in the trial court?
Lordship,
This matter was appearing yesterday, no?
No. No, Lordship. The respondents, Lordship, filed 7.1 and 7.2 applications. Both were rejected, Lordship. Thereafter,
who is your counterpart? You know? Not today, please ascertain. Who are the learned advocates for the plaintiff and the defendant both? Yes, next. None appears.
Appearing to the petitioner, plaintiff. Giving evidence followed, the defendant had discovered a document stating that the certificate was issued by someone in favor of the defendant. And that document was neither taken into evidence and but it was made exhibit. And again is that my lord, we preferred this revision application before it and your lordship has directed that the evidence should be taken to be given by the authority who has issued the certificate. And thereafter, my lord, the witness who issued the certificate, she did not come before the trial court, but paid for time that she could not come before the court as due to illness and age, as she is a very aged person. And thereafter, a commission was held in her residence, and evidence was taken, and that a report, or commissioner's report has been submitted, and that has been annexed. Lordship can receive the commissioner's report. And that from the commissioner's report, it is found that the contents of the certificate that has issued by that witness is not tallying with the evidence with the document. And we filed an application before the land trial court for rejection of the document.
Which has been marked as an exhibit. You want to expunge a document which has been marked as an exhibit.
Yes,
where is the provision in law? Once a document has been marked as an exhibit, can it be expunged? Where is the provision?
Hello, so for the lordship, kindly take it at 2 p.m. I am.
There is no provision to mark.
Hello, the document.
Yes, rightly. The learned trial judges. Ashun.
You see the impugned order, lordship?
Yes.
And lordship, kindly see the impugned order. That document.
Same was marked without raising any objection from the side of the plaintiff.
No, we made objection. And from the evidence followed, lordship, kindly see that we had made objection. At the time of filing of this document.
Where is your application? Please show me the application where you have sought for expunging of that document. Where is that? Where is your application which you have filed? For rejection of Exhibit 5?
Lordship, kindly take it up on Monday. On Monday, kindly take it.
On the Yes, next.
But I am paying for 1 day accommodation all year. You go for coaches out of station.
What is this matter?
I don't know. Yes, Chairman. I am not in the record also, but actually could be. But I am not ready. I am start with me over telephone. Take that and tell it for 1 day. Is it
On the prayer of the learned advocate. Yes, next. Yes.
Lordship, I appear for the petitioner.
Yes.
Lordship, herein after the issuing of the 13-2 notice, Your Lordship, there was a default from the very beginning.
Order 711, you want expeditious hearing.
Hearing, Lordship, the only difficulty was that 13-4 order was passed. 13-4 order was already passed.
13-4 surface.
That's section 14. In
Yes.
the order was already passed. Subsequent to the order being passed, which I have annexed as
Suit has been filed, injunction has been taken.
Lordship, suit has been filed, bank has been made
So
up.
bar under section 34.
Lordship,
You are taking the bar under section 34 in order 711.
Lordship.
Where is your application under order 711? What is the ground in Order 7, Rule 11? Yes, 34. This application under Article 227 of the Constitution of India is at the yes.
Suit has been filed by the petitioner in 2023, and thereafter the defendants appeared and filed an application under Order 7 Rule 11, which is on 19th August 2023. Since 3 years, the said Order 7 Rule
This application under Article 227 of the Constitution of India is at the instance of the is a miscase for?
My lord, the miscase was filed by opposite party number 2. My lord, an Order 9 Rule 4 application. My lord, there are Order 9 Rule 4 application, my lord. My lord, there are two applications pending in the miscase. One is an Order 21 Rule 16 filed by us and a Section 5 that was provisionally allowed. My lord, the title execution proceeding has been stayed, my lord. And the title execution proceeding is of 2019.
This case is Order 9 Rule 4.
Yes, my lord.
Title execution is pending.
Yes.
What was dismissed? Title execution of the suit.
My lord, we are for the decree holders, my lord, in this matter.
What was dismissed?
My lord, it was not dismissed, my lord. Let me just clarify.
Why Order 9 Rule 4?
My lord, Order 9 Rule 4 was filed by the opposite party number 2, claiming that
Petition is directed to serve a copy of the
Yes.
Or in a suit for in an ejectment suit, I file a 7-1 and 7-2 application. My 7-1 was rejected on the ground that I am a trespass. I'm a trespasser.
on the ground that you are a
Trespasser, and the suit has not been filed under Section 6 of the West Bengal Premises Tenancy Act. But
suit is not under Section 6.
But kindly see that plain, my lord. Kindly see the plain, my lord.
Is it under Section 6 or not?
Yes, my lord. The reasonable requirement is a ground. I was given 6-4. And a proceeding is also pending before the rent controller for fixation of fair rent for the last 10 years. But kindly see page 20, the plaint. Paragraph number 6.
What is the rate of rent?
185 rupees. But the proceeding is pending before the rent controller. I have annexed a document. Page 13 onwards. The predecessor in interest of the petitioners, he was the original tenant. Now, after his death, they're claiming that we are trespassers without considering the fact that we are statutory tenants.
Where is your application under Section 7.1?
Page 25.
Page 20?
25.
25. When did the defendant's father die?
Lord, 15th of August 2025.
15th of August 2025. The learned advocate appearing for the petitioner submits yes.
The petitioner's miscase under section 340 CRPC has been summarily disposed of at the time of hearing when the notice is required to be served on the opposite party or not. So kindly, my lord, kindly come to my applications of miscase, running page P5, page 89. Application
Rejection of 340.
340.
Is it a revisable order?
No, because kindly, my lord, come to the impugned order, my lord. Kindly come to the impugned order.
No, I'm asking you.
Miscase,
Rejection.
yes, miscase has not been rejected. It has been disposed of. Well, kindly see the impugned order.
Whatever it is it a revisable order? That too in civil division application.
Because my lord, the order has been passed.
You have authorities. Have you considered this aspect? There's a division bench judgment, as far as I can recollect. And it is to be heard subject to correction by a division bench.
Appeal would, I cannot file
Sir,
the appeal.
have you checked up this
Yes,
disposal?
Because
Do you have any authority that a civil division application lies against this?
Because I cannot file the appeal because this case has not been rejected, my lord. It has been disposed of.
That is what I am saying. If it is disposed of, civil division application is maintainable. I am asking you. Have you considered this?
Then my liberty be given to file an appropriate appeal.
Have you considered this? I'm not saying. Please consider this. Come back.
Then kindly fix it on Monday.
All right.
I will see the judgment.
Please consider this,
Yes,
because
yes,
what
ma'am,
is
I
the
will-
effect?
Because the order, while at the time of hearing whether the notice to be served on the opposite party or not, in case of a preliminary inquiry.
Because see, the ordering part says petition under section such and such, corresponding to such and such, praying for sending this petition to the learned CJ Alipur for taking cognizance of the alleged offence stands rejected. So it's a procedure step towards registration of a complaint. Whether a civil division application is maintainable, please consider this aspect.
Kindly fix it on Monday. I will satisfy.
The issue that arises for consideration
I was praying for a adjournment because the other respondents has not been served. Only caveator has been served.
Lord, I am for the respondent number one.
Caveator has not been served.
Has been served.
Lord,
Then
here.
court trust has to be served a lordship because he is also a necessary party. Because it's their deed which they have challenged.
What is the order under challenge?
Order 7, Rule 11 application, it has been a lordship.
Has been?
May I indicate your lordship?
Order 7, Rule 11 of what?
Lord, an application under Order 7, Rule 11, along with Section 151 of the Code of Civil Procedure, was filed by my learned friend. Lord,
Order 7, Rule 11 on what ground? What was the suit for?
Lord, suit is essentially, Lord,
May I indicate,
declaration or cancellation of a deed which has been executed by my learned senior friend's client with the KOPT. Lord, once that deed has been, Lord, your lordship will also recall there's another application which your lordships are hearing, which is item number 59, which is against the execution of a decree for eviction passed against me. Lord, this is a separate suit which
Order
has
7,
been
Rule
filed.
11 is on what ground?
On a ground that they are not the necessary party. Our
Can it be a ground under Order 7, Rule 11?
May I indicate it to your lordship?
Lordship will take it up. The seniors are there. Lordship will take it up on the next day.
Let me see whether the other side's presence is required or not.
May I, my lord?
Lord, Section 8 would be a bar as well. Lord, Section 8 of the Commercial Code side. See that.
টাই তো এটা হলো।
এটাই 34 Great.
My application.
Yes, what is this for?
Petitioner is the plaintiff before the learned trial court, lordship.
Yes.
Petitioner lordship, he is the owner of several passes, lordship, that are applied on public roads, lordship. Out of them, lordship, the one bus was agreed to be sold to the defendant. The defendant had made a part payment, lordship. The physical possession was full. The physical possession was, lordship, handed over to the defendant.
Yes.
The total consideration amount was not paid. So, my lord,
Total consideration not paid.
not paid, but the vehicle was handed over to the lordship, to the defendant, along with the documents of permit and etc. Lordship, the suit was filed. Thereafter, lordship, during the pendency, lordship, an application under Order 30, Rule 5 was filed by the plaintiff. And lordship, that application was rejected at the threshold. Lordship, only a so-cause notice was sought to be issued, lordship, under the Order 30, Rule 5. And without calling upon the defendant to appear, lordship, the defendant had appeared in the suit, lordship, but thereafter he took time to file his written statement, but preferred not to appear thereafter and did not file his written statement, lordship. And lordship will kindly find the grounds of rejection, lordship, at my improved order. Lordship is looking at the provisions, lordship. Regarding whether it is appealable or not, lordship, probably that is Order 30, Rule 2, 3, and 6 are appealable, lordship.
Where is your application?
Lordship. So at page 50, 50.
50.
Lordship. The prayer portion is at lordship 59. So as far as the plaintiff could ascertain, lordship, 3 vehicles were registered in the name of the defendant, lordship. The information was collected from the road transport authorities, and that has been annexed to the application, lordship, which will appear herein from page 47. All I wanted to seek and all I wanted to do to run a Calcutta was not an order directing the defendant to appear and so forth as to why he should not furnish any security.
Where is your application? Page 59 is the prayer.
Lordship. Application starts at page 50, Lordship.
Where is that agreement? 20th of December 2019.
It's at page 26. 26, Lordship. It's an unregistered agreement, Lordship, but signed and duly delivered. At page 27. But it starts at page 26, I'm sorry. At page 27, Lordship, 2, 3, 4, 5. The fifth paragraph, Lordship will kindly find that the above first party, that is the plaintiff, has sold and delivered this bus number such and such to the second party on 8/12/2019 at such and such time, and also delivered RC, tax token, insurance certificate, etc. to him. And this has been signed by the defendant. The payment terms as well agreed between the parties, Lordship, are recorded in paragraph number 2 of the said page, Lordship. The total agreed amount was 11,25,000, which is to be paid in 25 in EMIs of 25,000 each in 45 months. The defendant paid only.
What happened to the Order 40 Rule 1 application?
Order 42, yes, 46. Lordship, that was rejected by the same order.
Have you challenged that?
No, Lordship, I have not. That I have pleaded in my application, Lordship. That has not been as yet. That was both the applications were rejected by a common order, Lordship.
By the order impugned.
Yes.
The Yes, next. Yes.
Your Lordship, Your Lordship, 36.
No, item number 4. This is the
36 for
extension. It was passed over. Yes, you have served. If it is service filed, they have received. Yes.
Mr. Banerjee is appearing online.
Lordship,
Yes.
I appear.
Yes.
Your Lordship, that matter where Your Lordship asked me to inquire who is there appearing before the Baruipur court. Your Lordship, for
Yes,
that,
yes.
my advocate appearing in the court below is present before my Lord to clarify that who is appearing. On Mr. Supriyo Chakraborty Chatterjee is appearing for the plaintiff.
Is there any difficulty on my part to take up this matter? All right. Yes, what is this matter? What do you want?
This is a matter where Your Lordship, I want expeditious disposal of my order 39 rule 4. Interim order was in June.
This application under Article 227 of the Constitution of India.
There was a leap problem. Leap was
37, yes.
Your Lordship, only one thing, I'm very sorry to
Yes.
disturb.
Yes.
36, but I could not hear the date because the screen was off. The time period.
I've directed to dispose of expeditiously, to take up the hearing on the next date and to dispose of expeditiously. Yes, next matter, who is appearing? Yes.
Mr. Vishwajit Pal is appearing for the plaintiff and Mr. Devasis Chakraborty.
Since I'm not inclined to take up this matter on personal ground, this matter stands released.
Petitioner at the outset playing leave to corrects the cost title the opposite party numbers once name ought to be deleted because he's no more this is personal this matter
He is opposite party number
one
is to
he
be
is no more he expired during the proceeding, my lord. His name has been, my lord.
During this proceeding, which proceeding? Civil division application?
No, before the suit in the court.
All right, yes, what is this matter?
My lord, this matter, my lord, before, my lord, placing the impugned order, my lord, may I just place the factual background, my lord. Partnership was entered into by the defendant number 1 and the plaintiff petitioner before your lordship, my lord. Suit property was
Defendant number 1 is who died?
who died. A suit property, my lord, the partnership purpose is a suit property which is to be used for mining purposes. Is to be used for mining purposes. A registered partnership was executed.
Then what happened?
My lord, now after the inception of partnership, he transferred the property to the defendant number 2.
Defendant number 1 transferred to defendant number 2.
Property to defendant number 2, in spite of the fact that this
So defendant number 1 was the owner, sole owner.
sole owner.
Yes.
He transferred to defendant number 2. My lord, we instituted the present suit for declaration that that particular deed is not operative, void, and for accounts because that suit property belongs to the partnership. Now, after the suit was filed, we preferred for an moved an application for interlocutory injunction. Injunction granted, restraining both the defendants not to interfere for the time being. But we served notices. Notices came back. The notice upon defendant number 1 came back with endorsement deceased. We have to take steps. Accordingly, my lord, we have preferred an application, and by that time elapsed, we have preferred an application under Order 22 Rule 9 for setting aside abatement, and there is also 5-6 days delay.
Defendant number 1 died when?
My lord,
Pre-suit or post-suit?
no, post-suit. Post-suit. But we preferred an application initially. The miscase on that particular date, the miscase of my Order 29 substitution, setting aside abatement, that application was on post. Initially, an order was passed. Yes, that is kept on record. Issue notices, summons were served, and suddenly, my lord, in the evening, that order was, which was uploaded initially, that order was, my lord, removed, and my lord, an order was passed that my suit abated. My lord, humble submission, my lord.
Suit abates.
Abated. My lord, my contention is that it cannot abate as a whole because the property, my lord, your lordship kindly sees. My lord, your lordship kindly sees the partnership deed. It's a registered partnership. It starts at page 27. 27.
No, what order you are challenging here?
My lord, my holding that the suit abated as a whole.
9th of June.
9th of June. Your lordship kindly comes to the order dated 22nd April 26 first. Order number 8. Your lordship kindly comes first. The previous order.
Where is your application under Order 22 Rule 9?
Yes, my lord. That is, my lord, annexed at page 84.
By the order impugned. Now, the learned advocate appearing for the petitioner the learned advisor. Yes.
Suit for declaration and permanent injunction. Suit is at the stage of argument when Milord the plaintiff had filed an application for amendment. Lord, that amendment
You
was
are plaintiff.
I am the defendant.
Plaintiff has filed an application for
Amendment of the plaint.
Yes.
Now, Milord, that amendment application was allowed. With respect to that amendment application, Milord, I filed an application under Order 8 Rule 9. That leave was rejected.
No, I could not follow.
Amendment of the plaintiff was allowed. Lord, with
Yes.
respect to that amendment, Lord, I filed an application under Order 8.
You are not challenging the amendment.
No, Milord, I have not challenged, Milord.
So, according to you, you want to file a subsequent pleading. Please show me the amendment application which was allowed.
Lord, amendment application is not here, Milord. I have annexed the order, Milord, which replicates, Milord. Kindly, Milord, comes to page 26.
Page
26. But first, may I take your lordship to the plaint, Milord? What was the original one? Milord, kindly, Milord, comes to page 14, Milord.
This is for Diamond Harbour.
Diamond Harbour.
Compliant plaint. This is the term used in that code. Yes. Yes, where is the plaint?
Plaint is at page 11.
This is the amended plaint or the original?
Plaint.
Amended plaint.
Amended plaint.
Show me the amendment which was incorporated.
Page 15, Milord, paragraph 12, 12 co. 12 co. Says, Milord, the LTI is similar to
Please give me a
Exhibit
minute.
1.
Yes, show me your application under Order 8 Rule 9.
Yes, and that. Lord, the leave application is at page 37. And Milord, the additional written statement is at page 34.
Yes, in the order of amendment,
Yes.
you are given liberty to file additional
Written statement.
So,
Milord,
you have not filed within
no,
that
Milord,
time.
no, I have filed. I have
When
filed.
did you file?
I have filed page 32, Milord.
When did you file?
13th of November.
13th of November.
2025, Milord. Page 32, Milord, that is the additional written statement. Milord, I have denied the amendment which was sought to be incorporated.
No, no.
Yes.
Para 2 of the amended plaint.
Yes.
So, this is not the subsequent pleadings.
No,
Now you are trying to deny everything.
No, Milord. Kindly, Milord, see page 32. Page 32.
No, 29 is the additional written statement.
No, that is with respect to some other amendment which they had sought. But this is this additional written statement is with respect to Milord para 12. But kindly, Milord, comes to page 32.
No, which additional written statement was rejected? Which additional
my leave was rejected, Milord. My leave application is at page 37.
37.
Page 37. This is, Milord, the leave application, and Milord, the additional written statement is at page 34.
No, you previously filed additional written statement.
Filed written statement. Now, my lord, I want to
Written
elaborate.
statement as well as additional written statement.
lord.
When did you file the additional written statement?
On 13th of November 2025, my lord,
Yes, so that is on the basis of the
amendment. On the
yes,
basis of the amendment.
then
Thereafter, my lord, I want to elaborate. My lord, kindly, my lord,
no,
see
no, that is not
page
permissible.
34. Kindly, my lord, comes to page 34. My lord, what I sought to incorporate. My lord, kindly, my lord, comes page 34.
Yes.
Page 35, para 8, my lord. That
Yes.
this defendant submits that the alleged sale deed execution and registered dated 24th of June 2002 in the office of the sub-registrar Falta and recorded in book number 1, volume number 21, pages 39 to 46, deed number 1654 for the year 2002 is forged, manufactured, false, fraud, fake, fictitious, and the alleged deed is not binding upon the defendant number 1, as the alleged deed was typed by one Sri Ramchandra Ghosh at Alipur Judges Court, and also the deed writer Abdul Basad Mullah signed at Alipur Judges Court on 24 June 2002. In the same date, the deed was presented at 10:45 a.m. before ADSR Falta. Moreover, the alleged deed, if registered on 24 June 2002, complete the same but after 5 years on 24th of June 2007. The same ADSR Falta signed the alleged deed without any reason. One ADSR Falta put his signature on the deed of registration, but in the volume copy of the deed shown that another registering officer signed on the same date, and true copy of the alleged deed was prepared on 31st of December 2003 without any reason. The alleged vendor Jahanara Bibi of the alleged deed did not put her LTI upon the alleged deed. Lord Miller,
Mundol, when this additional written statement at page 29 was filed?
Tenth of February.
Yes, not on November.
No,
2025.
page
You
30.
said November.
No, this is with respect to some other amendment which they carried out.
I asked you page 29 when this.
Page 29, this is an additional written statement filed by my client with respect to a amendment, some other amendment, Millard, which the plaintiff had carried out. Page 32 is the amendment with respect to para 12, Millard.
Please kindly come to the order allowing amendment that is at page 26.
Yes, Millard.
So by this, you are directed to file additional written statement.
Yes.
Pursuant to this order, which additional written
Page
statement you are filing?
Page 32.
Cannot be.
Kindly, Millard, please.
This is on April.
No, it is on 28th of July 2025. The amendment was 28th of July. 28th of July. Kindly, Millard, please. Page 26.
Yes, 28th of July.
July.
So amended plaint was directed to be filed on 18th of August,
Yes.
2025.
Yes.
And you filed the additional written statement when?
On the 13th of November 2025.
Please show me which page.
Page 29. Can you see?
Page 29 was filed on.
Page 32. Can you see? Page 32.
Not 32. Page 31 is page 29 is the additional written statement when this was filed.
This is with respect to some other amendment which they had carried.
Which amendment? Please show me.
That, Milord, I need to. With respect to RS Pocha, kindly, Milord, sees what I have denied in that page 29 application.
This additional written statement has been allowed.
This application was allowed.
When it was allowed? By which date? On which date it was allowed? It was filed on February 2026. Yes. On which date this was allowed? How many additional written statements will you file? On February 2026, on April 2026?
Page,
nothing but to delay.
No, Milord.
Yes.
No, Milord. No, Milord. Milord,
yes.
The suit was at the stage of argument. Plaintiff filed an application for amendment. Milord, thereafter, Milord, I filed.
You are not challenging the application for amendment. So now you are trying to. When this page 29 was filed, pursuant to which order?
Milord, order number 58, Milord.
Order number?
58, Milord. That's in the certified copy, Milord.
Page.
Certified copy.
Certified copy.
Certified copy. 58, Milord.
Yes, this is the amendment petition
filed with by the plaintiff with respect to Milord. Kindly, Milord, sees
It has been stated the petition that during drafting of the plan, plaintiff could not provide RS Khotiyan number. Afterwards, the plaintiff obtained the certified copy of RS Khotiyan in respect of the suit plot, which is very essential for effective disposal of the suit. Accordingly, learned advocate for the plaintiff praised for amendment of the plaint in terms of the above petition. Now, my lord, with respect, this amendment was allowed.
Mondal, order dated 28th of July 2025,
Yes,
there was a direction to file additional written statement.
Yes.
Pursuant to this, which is the additional
Page
written statement?
32. Page
32.
Page 32.
So page 32, you have filed on February.
No, 13th of November, page 33. Kindly, my lord, sees. Page 33.
32, page 29, you have filed pursuant to which order?
Page 29 was filed pursuant to, my lord, this order number 58, 10th of
Order
December.
number
58.
58.
58, my lord, dated 10th of December 2025.
10th of December 2025.
Yes.
And page 32?
Page 32 is with respect to, my lord, 28th of July 2025.
So the earlier amendment, you are filing the subsequently additional written statement. When you had the opportunity to file,
Kindly, my lord,
this is
foundation is there, my lord. I need to just
you
elaborate.
had the occasion in February, deliberately not filed. So previously you had an opportunity to file an additional written statement.
Yes.
You chose not to cover up. Piecemeal, Mr. Yes, now let me see the reasoning.
Now, my lord, kindly, my lord, see what they are trying to incorporate. Kindly, my lord, comes to page 14, my
Yes,
lord.
that maybe it's not a matter of right, it's the court's discretion.
No, my lord, kindly,
Order 8 rule 9 is the court's discretion,
yes,
not
that
as a
is-
matter of right.
that
Please
is
let me see. If you have not filed your additional written statement within that time, it
I
cannot
have
be
filed,
done.
my lord. I just know now, my lord, I want to
Yes.
elaborate, my lord.
Yes, please show me. The impugned order is 4th of July or 17th of July.
4th of July as well as, my lord, the 17th of July. 4th of July, my lord, my leave application was rejected, and my lord, on 17th of July, my lord, my DW was closed, and on 30th of July, it was fixed for argument.
Where is your original written statement?
Original written statement is at page 19.
Page?
Page 19, my lord.
19.
19.
So this is the deed. The deed was dated?
Deed was dated, my lord, on 24th of June 2002. And
24th of June 2002.
Yes.
What was your averment in the original written statement with regard to that deed?
Page 20, my lord, para 9. Lord, they say, my lord, my predecessor in interest, my lord, sold the land with respect to this deed.
Yes, you have already stated these facts in the original written statement.
Yes, I have stated.
Then
I have stated. Now, my lord, what they had sought to incorporate. Kindly, my lord, comes to page 15.
Page 15, yes.
My lord, 12 co. 12 co. Para 12 co.
Yes.
Para 12 co. Kindly, my lord, says that on 3rd of July 2025, ADSR Falta submitted a report along with a photocopy of the TI book.
They have only stated with regard to those facts, with regard to the exhibit.
No,
Nothing.
No.
Yes.
Kindly, my lord.
Yes.
With report along with a photocopy of the TI book dated 24th of June 2000.
Those are exhibits. Already marked as exhibits. They have pleaded that fact.
Now, my lord, what that stated, my lord.
Yes.
In that document, there is mentioned TI number 1826 to 1840.
Yes.
TI number 1827 reflects Jahanara Bibi Bokolome Moharam Khan, which is similar to Exhibit 1. Exhibit 1 is the deed my lord 1654. By which, my lord, they have stated, my lord, my predecessor in interest has sold the suit property to them.
13th of July 2027 is the next date fixed.
Must be a typing it. That must be a typing
Learned
it.
judge was frustrated with your conduct.
Not my conduct, Milord.
Fixed 1 year after. In July 2026 as fixed in July 2027.
This must be a typing mistake, Milord. This must be a typing mistake, Milord. My counterpart in the court below had inquired, Milord. It was a typing mistake. This was a typing mistake.
Petitioner is directed to serve a copy of
Argument was no time petition will be allowed even on the personal ground of the learned counsel. Parties are at liberty to file written notes of argument, Milord. It is at this stage, Milord. Kindly, Milord, can ask me something like that.
(105) amended. Right hand page, right hand page. It has been amended. Perhaps it's the latest. Thank you. Please take information if it is pre-13th, 2026, not 2027, because it's fixed on July 2027. Yes. Just call the next matter.
Order number 40.
This is my application. I am praying for expeditious disposal of my 151 application pending before the learned court at Badavipur.
Who are appearing?
My lord, for my client, my learned senior, Mr. Shukrit Mukherjee and Mr. Chitranath Sarkar. And for the opposite side, it is Mr. Deepak Balmiki and Mr. Soumendra Rai Choudhury.
This application under Article 227 of the Constitution of
The light color is coming up.
of stay of the order passed by the
Here for the opposite party number one, we are on caveat.
I have served this. No question, we are moving expert. I have served them, I am moving on.
Yes.
But the order will like I say, will like a society. There are flags in the society. There is a trust.
For that matter,
Yes. Today, it's a trust.
serve.
They all there served everyone. They're appearing. This is the third time the matter is appearing.
So tomorrow, 2 p.m. Come at 2 p.m.
2 p.m. Lordship will do it 2
Mr. Mitra was waiting for this matter.
Yes, yes.
Ask him to come at 2 p.m.
I'll come at 2 p.m.
Yes. This was what has been done.
Kindly, Lord.
One indulgence I'm seeking. Item number 2202, content matter. Your lordship will take up this matter as per the list minute from 3:30. But I'm only seeking indulgence. I'm intimated the other side, inform other side. But if your lordship kindly takes it as a fast matter, because I have to catch a flight today.
You have?
I have to catch a flight. I have to leave court.
Lawyers, Mr.
No,
Bose.
I'm only, I'm embarrassed. If your lordship kindly gives me that indulgence today, otherwise I would not have disturbed your lordship.
All right. Item number
2202.
2202 একটু mark করে রাখুন, ওটা একটু আগে।
My lord, may I have my lord's kind leave? My lord, I'm sorry, my lord, my video is off. My lord, there's an extremely urgent matter, my lord, which we have filed in the morning today. We have been asked to vacate a property, my lord, in Salt Lake by DRAT. DRT, my lord, was in my favor. An impartable property where, my lord, I've been asked to vacate, my lord, though I am not even, my lord, a mortgager of that property. My other co-sharers, my lord, they had mortgaged it, but I have been asked to, my lord, vacate the property immediately. Kindly, my lord, keeps it tomorrow. We have filed it. We did not mention in the morning, my lord. It's only because we did not want the, we wanted to file it and get the number. We've got it, my lord. Kindly.
May I hand up the number, my lord?
Yes.
My lord, may it be fixed in the morning, my lord, tomorrow if it commences to your lordship.
Will appear, Mr.
Because-
Chatterjee, let me see.
Lord, with regard
Very
to
well.
item 39, my lord, on 30th of July, the court took up the matter, and my lord, the next date has been fixed on 12th of August.
12th of August. তাহলে ওটা I'm keeping it on 12th. 12th of August, ওই item number
39.
39, ওটা
Kindly, my lord,
13th of
protects-
August পড়ছে, ওটা 12th of August.
Kindly, my lord, protects me for, kindly, my lord, protects me for a limited.
Item number 241.
In this matter, Saptoshi Kundu is appearing when he asked me to pay for a password.
Yes, no.
So, oh, yes, come, sorry.
Yes, what is this matter?
My lord, I have got the injunction order. Thereafter, I prayed for 151 police help. Police help prayer granted. In
Police
spite
help
of
prayer allowed.
allowed.
Then what happened?
In spite of that, they are destroying my crops. I have again applied for proper implementation of the order. That application has been rejected. I have taken the photographs also.
No, the police was directed to appear. What happened on 6th of March 2026?
Police saying they have taken steps, but
Yes.
but in reality nothing. Because lastly, I have the
What can be done here? Because the order has, your application has been allowed.
Yes, because no, I am only praying for a direction to implement it properly. But police is not
That,
doing anything.
for that you will be entitled to apply there. The order is in your favor. What can be done? How can it be interfered with? The learned advocate appearing.
Come back at 2 p.m.
There are 2-3 upgraded matters thereafter.
Very good. Whatever.
Yes.
Under section 218.
Mr. Mitro, only 2-3 matters, those are fixed. After that, I will be taking up that. Yes, yes.
Under section 218 of the West Bengal Municipal Act, my lord, the municipality passed an order of demolition.
Authority passed an order of demolition, you have challenged?
Against that is a opposite party. And against which, my lord, an appeal is against which, my lord, an appeal is prepared by the under the law.
218 subsection 3.
Subsection 3 appeal is prepared.
Yes, then what happened?
And that appeal, in that appeal, my lord, the municipality did appear, my lord, on that day. And thereafter, my lord, what happened, my lordship, kindly see the last order.
Yes.
Against the order of injunction, my lord, they often order an injunction against which, my lord, appeal was preferred by the majority. And that appeal has gone to it before the court of executive judge, additional judge. Now they are in doubt. The court is a doubt. This junction, this court is an opinion to decide.
You are challenging the order dated 12th of September 2025.
My lord.
Yes, so by this order, it has fixed for hearing on the mentality issue. What happened on that?
My lord, nothing has been.
What is the next date fixed?
Next, my lord, in the month of September, I think, my lord. But this court is the last paragraph, my lord, of the order. In this junction, this court is of the opinion that opinion to decide asked whether this court has any jurisdiction to hear any misappeal against the order of the misappeal passed by
Yes,
the
yes, rightly so. Because whether this miscellaneous appeal will lie before the civil judge junior division or additional district judge. Rightly, the jurisdiction point has been raised. Because it is to be filed before the learned civil judge junior division.
Now your lordship kindly decide whether it will be filed.
The learned judge has fixed this on mentality issue. I direct the learned judge to decide on the mentality issue. When it is fixed, next date.
I mean, exactly, do not know the date, my lord. In the month of September, I understand.
September, all right. As possible. Next.
Well, this is my application. I have an
Yes.
But I am for the defendant petitioner suit for eviction. But suit was earlier dismissed on 17th of May 2000. Thereafter, file an application.
Was dismissed on thereafter order 9 rule 9.
Rule 9 that has been allowed.
That has been allowed.
That has been allowed. There was suit was decreed ex parte. They filed an title execution case. In a title execution case, they filed an application miss case, which was miss case registered under 18 of 2023 for police. That has been dismissed. Also, but they preferred an application under Order 9 Rule 9 also. But that was allowed in the impugned order. Before that, kindly see the Annexure C, page 26. My relevant portion is page 28, middle portion. Save and accept the aforesaid statement. Petitioner has not stated anything regarding the delay cost.
Page 26.
28, my lord.
28.
Middle portion, my lord. Save and accept, as your lordship kindly.
Yes.
The aforesaid statement, petitioner has not stated anything regarding the delay caused in filing this application even after 5th of August 2000, when he had the knowledge about the dismissal, which is the admissible statement of PW1. he had come to know such and such that the suit has been dismissed, but the miscase has been presented only on 4th of September.
No, that miscase was allowed.
That miscase was allowed, my lord.
Then what happened?
Subsequently, my lord, kindly see the impugned order.
Yes.
They have filed an application, my lord, in title execution case in miscase number 66 of 2016. My lord,
What is this miscase for?
for police help.
What happened? That was dismissed for default.
No, my lord, that was allowed.
Why order 9 then?
Blood, kindly see the miscase on dismissed on 3rd of September 2016.
Yes,
Thereafter
dismissed for default.
Dismissed for default. Thereafter,
so-
thereafter they filed an miscase. In
Yes.
this miscase, the order has been passed. And madam, also, madam, next impugned order also, we made an application under
That
section
has only
47.
been restored.
No,
Mr.
madam,
Shah, you
kindly
are
see-
opposing the
madam, kindly-
restoration.
madam, kindly see.
Mr. Shah, you are opposing a restoration
No, madam, kindly
application.
see my section
I
47.
will remember this when you come up with an restoration
My
application.
kindly see, blood, my kindly see this aspect. As a last chance on 12th of a for PW.
Yes.
In title execution case. In title execution case, some of the plaintiffs have died.
It has been
They have not
restored.
made substituted.
I can expedite the miscellaneous case.
Blood,
Mr. Shah,
my
restoration-
47 application has also not been rejected. Kindly see last next
47
order.
has been rejected.
Yes, kindly see next.
Yes, so.
My
So that is your
kindly see next.
47 on what ground, Mr. Shah?
On 28th, on the same day.
On what ground?
Not.
Why the degree is inexecutable according to you?
Now kindly see.
What is the ground in 47? Oh, the suit was decreed without giving any opportunity.
Opportunity.
That is the ground in section 47. Ashok, this application.
Kindly give this opportunity.
47, that cannot be a ground. In the suit, you are not given opportunity to hear, to contest.
No, in the title execution case, some of the plaintiffs has died. They have not made party to their heirs.
47, this is the order.
Within short period, I shall serve again.
No.
Kindly see.
Contest the miscellaneous case, it is fixed for evidence. Take all points there. This application under Article 227 of the Constitution 1101.
My lord, in this matter, I will for the my lord, completely mercy petition. I leave to your lordship, my lord. Whatever it is-
petition?
Yes, my lord. During Ramzan month, that date was fixed for adduce the evidence of petitioner witness. I have made an application for adjournment. That was rejected and subsequent closed the date of for adduce the evidence of petitioner witness. Kindly see the impung order.
How many dates you? Special last chance.
Kindly consider, my lord, so that the court can take this.
How many witnesses you have? This was PW2 was closed.
Yes.
How many more witnesses you have? Another two.
No, one. Last.
This is the last
one,
witness.
one chance, my lord, kindly.
By the order impugned.
For the petitioner, I have challenged an order, ex parte in maintenance order, my lord.
Ex parte?
Maintenance order passed by the learned court. My lord, the petitioner filed an application for restoration of conjugal rights, section 9. Husband. Thereafter, one application for under section 24 filed by the wife. My lord. Is a working late. My lord, thereafter, an ex parte interim order has passed. I have challenged an execution order. My lord, kindly come to page 107.
What is the order under challenge?
Under challenge, my lord.
6th of October 2023.
Yes. My lord, I have challenged the order passed by the learned court. Subsequently, coordinate bench of this court stay the execution case. My lord, kindly come to page 107.
What can be done? You did not contest on repeated opportunities.
107, my lord. The learned, the honorable court stay the all proceedings in matrimonial suit. Page number 107, my lord. Thereafter,
That is
my
neither here nor there. This is alimony proceedings.
yes, my lord. Thereafter,
What are you doing? What is your income?
income, my lord, 16,000 and
16,000. Your income, what are you doing?
home guard, my lord. I have annexed the payslip, page number 66. And my lord, kindly come to once the order passed by this coordinate bench of this honorable court. 107, my lord.
107.
Yes, ma'am. And UD, I have also filed an application for vacating the ex parte without considering that this final order has been passed, ma'am.
No, what stay? Stay of the matrimonial suit.
Yes, my lord. Kindly come to 79. Page number 79 of my.
Stay of the matrimonial suit, not stay of the miscellaneous case.
My
Then
lord, yes, my lord, kindly come to 79 once.
page 79. Yes.
I have filed an vacating for ex parte petition, ex parte,
That's in the suit.
but without disposing.
That is in the suit.
Okay. No, not in the suit, in this miss case. Kindly come to page 79.
You have not paid anything.
Yes, till
How much?
2,60,000 till now.
When? 2,60,000 is the arrears.
No, my lord. Total 2,60,000 I have paid, my lord. I
Till
have,
which date?
that I have to assert, my lord. My lord, the petitioner.
Your written objection, you have filed the written objection in the miscellaneous case.
Yes, my lord. Yes, my lord.
Where is that?
My lord, page number 57 to 60, my lord.
57 to 60.
The wife is also earning member, my lord. I have annexed the appointment letter of my wife and also the bank statement. The appointment letter in page number 31.
Yes. What do you say? I'm directing, because it was an ex parte order, I'm directing the learned trial judge to consider this.
My lord, my learned friend's client filed order 9 rule 30. And order 9 rule 13 application, that is disposed of with the findings that this was not a decree in the form. My lord, after that, and my lord, several opportunity has been given, and then several
Last opportunity. When is the next date fixed?
my lord, already warrant issued against him. My lord, the due is by taking privilege of this order passed by this honorable High Court.
What is the amount of, what is the
My
amount
lord,
due?
as per instruction, 5,61,000.
You have to put in some amount.
I have already paid.
And my lord, by taking
You have already paid how much?
1 lakh. Thereafter, the
1 lakh by this.
warrant is kept in abeyance, my lord.
What is the total amount due now?
That I have to ascertain, my lord. My
Please
only
put in 3 lakhs. I
Yes.
direct the reconsideration.
Yes.
The amount, what will be ascertained, that will be adjusted with that amount.
Kindly consider that I have earning 16,000 only. How I will pay 15,000 as an alimony, my lord? Kindly
No, this will be adjusted. Some amount you have to pay.
my lord, yes, as per direction of the honorable court, I have paid.
My lord, that direction has been
According
given
to her, that
2022.
according to,
Thereafter, my lord, I have already.
what is the amount due as on date?
5,61,000.
Yes.
My lord, I have to ascertain
She is
that.
saying 5 lakhs.
My lord,
You are saying 1 lakhs you have paid.
my lord,
So 4 lakhs is
my lord,
due.
I am not denying that I will pay. My lord, kindly allow me to contest this.
I will allow you, but please put in on at least 50% of the amount due. Please put in 50%.
Paying regularly, my
No,
lord.
no, no,
Till
no,
now,
no, no, my lord.
My lord, I can show.
All right, that will be adjusted.
My lord, I
How
can
much you are paying? When you have last paid?
2,60,000. Last
Including
occasion-
1 lakh.
No, no, no.
When have you last paid?
On the last occasion of my date, I have paid
When?
60,000.
When?
My lord, I have to ascertain.
Please ascertain. Please come with the detailed calculation.
Yes,
Give it to her. The amount due. You
And
have
I
to,
have a my lord
you have to
school-going
put in
children.
50%.
I am not denying that I will pay. Both we are earning, my lord. I will
No.
pay for the children, my lord. I can show you that 2,50,000 is remain paid. I have to pay.
2,50,000 is due. So pay 1 lakh according to your own. Pay 1 lakh. I direct the section 24 to be disposed of. When
My
is the
lord,
next?
that is completely wrong, my lord. Submission made from the bar. My lord, that due, my lord, after passing of this order, only 1 lakh has been paid and nothing has been paid. My lord, for
All
that
right, give her a calculation. Let her. The learned advocate appearing. Wednesday, I will consider. Please take instructions. You have to, the amount due,
Yes.
you have to put in 50%. as a condition, then
May
it
I
will
have
be
to- my
considered.
lord, may I have to file supplementary affidavit for the payment?
Not supplementary, give her a calculation, supplementary affidavit
That
is
I-
not necessary.
that I-
Grateful, my lord.
Yes, call the next matter. Yes. Who is appearing? This matter was mentioned by the connected application, if any, stands accordingly disposed of. Yes, next.
And I am opposing.
Well, to recall one of this matter, I just want to make brief submission. But I am.
It occurred.
Is a present.
Huh?
Is a present.
Different numbers 4 and 5.
Yes.
In one of the suit. One of the suit. Subject matter of the suit. Is.
So Banerjee, what is the impugned order?
Impugned order, my lord, is of the first appellate court, which has refused to stay an ex parte ad interim.
Stay of
ex parte ad interim order. We had asked, my lord, for a stay of an ex parte ad interim order.
Miscellaneous appeal is to be disposed of, Mr.
So that is
Banerjee.
always an option. But my lord, I want to show, my lord, on the face of it, the suit is so misconceived, my lord, that no order could have been passed ex parte. Two reasons. One, my lord, on the face of it, the suit is misconceived. Second of all, my lord, as we understand, my lord, under Order 39, Rule 1 and 2, my lord, and 3, if, my lord, you have to get a ex parte ad interim order, you'll have to show the urgency or give the urgency. My lord, this ex parte order was, my lord, of April 20th April 2026. And according to their own averment, the urgency was as on 31st July 2025. 10 July 2025. On that ground alone, my lord, no order should have been passed. No order should have been passed. I'll just briefly, my lord, tell my lord what is the subject matter of the suit. My lord, there's a syndicate, my lord, which was formed, my lord, by, my lord, certain, my lord, companies, which, my lord, wanted to have, my lord, interest in immovable property. Like, my lord, nowadays, my lord, you have cooperatives and all that. My lord, in 61, my lord, they decided, my lord, to form a syndicate. These members, and I'm, my lord, the part of, my lord, the original, my lord, syndicate member, my lord, at 61. Now, my lord, Mr. Mitra is, my lord, for the syndicate. Now, my lord, this syndicate, my lord, then caused.
Who are you? What is the relation between you and Mr. Mitra?
My lord, Mr. Mitra, my lord, is a syndicate. I'm, my lord, a member of that syndicate.
Malad, there is a mention about a syndicate and of an agreement of 61. That's what I heard. Malad, this document, Malad, was never there before the trial court at the time of ex
Let
parte.
us assume it was not there. Doesn't matter.
Just a minute, Mr. Banerjee.
I've just started my petition.
I've
If you
just
start interrupting,
yes,
then
because
there's a
you should
problem.
have said that there is an application pending, which I have taken out, Malad,
That's not
for
required.
expunging.
Mr.
Yes,
Ray, I know what I have to say.
Then why are you mentioning the 61?
May I just
Please don't. So that is
Mr.
why I'm
Ray,
just
Mr.
pointing
Ray,
it out,
please may I
Malad.
continue? That is also mentioned in your deed itself.
I'm making a submission to the Honorable Judge, Mr. Banerjee. I'm just pointing it out that 61, I've also taken out an application that he cannot rely on it.
My lord, my request
Because that
is,
was
Mr.
never
Ray should not
before there.
For the,
my
The trial court.
Before the appellate court.
Even the trial court.
My lord, my request is, Mr. Ray, my lord, should not interrupt. My lord, I know his anxiety, my lord, in the matter, but my lord, so my lord, there was a syndicate which was formed. My lord, then my lord, these members invested money. My lord,
You are one of the members of that syndicate.
and my lord, I'm the beneficiary. I'm just, my lord, getting. So what happened, my lord? So a whole lot of, my lord, a property was bought in the name of a trustee. Money contributed, my lord, by the members. Then, my lord, a trust deed is also, my lord, entered into, by which, my lord, the flat owners, the 40, my lord, on DL Khan Road, are the beneficiaries of, my lord, all these flats. And the trustee is appointed, who was, my lord, Mr. Ray's client, as, my lord, known as Dalhousie Holdings Limited, to, my lord, have the legal title in the property. That's how, my lord, a trust works. Now, my lord, in terms of, my lord, the Trust Act, my lord, knows, and that is what I want to show. A trustee's interest has to be aligned or as the same as the beneficiary's interest.
and only for the purpose of the trust. Otherwise, my lord, the trustee, my lord, as such, has, my lord, no independent interest. That's, my lord, the law. And, my lord, if he acts contrary to the interest of the beneficiary, that's, my lord, section 14, then, my lord, he is really, my lord, liable, my lord, as being, my lord, in breach of the trust. Section 58, my lord, permits the beneficiaries also to transfer their beneficial interest. That's, my lord, how the situation, my lord, I'll show the deeds which are on record and which are, my lord, admitted deeds. Now, my lord, what this trustee does is, my lord, on the basis that, my lord, he has, according to him, he has found out that, my lord, the beneficiaries has transferred, my lord, their interest without a registered deed, according to him, and without his information, filed a suit, and, my lord, asked for certain reliefs. Now, my lord, I want to first show, my lord, some of the reliefs in the plaint, my lord, why I'm saying, my lord, it's misconceived. Then, my lord, show what is the real intention of this so-called trustee, who says who wants to protect the interest of, my lord, I don't know whose interest he wants to protect. My lord, kindly, my lord, first come to, my lord, the plaint, my lord, which, my lord, will find at page 386. My lord, 386, volume 3. $386, my lord, will find. That's, my lord, the cost title. Dalhousie Holdings Limited, my lord, that is, my lord, the trustee.
Yes.
And, my lord, these defendants 1, 2, 3, all, my lord, beneficiaries holding, being, my lord, beneficial owners of flats. Then, my lord, 4 and 5, my lord, is who are the petitioners before my lord. The
4 and 5 are the petitioners.
Before my lord.
Yes.
Exide Industries and Merge Statesman.
And 1, 2, and 3 represented by Mr. Mitro.
No, my lord, they are also beneficiaries. Mr. Mitro, my lord, is an 8 at page 388.
Mr. Mitro is 8.
8. The others are all, my lord,
Mr.
beneficiaries.
Ghosh is assisting Mr. Mitro. Yes.
Now, my lord, kindly see 389. What is the suit for? Suit for declaration, recovery of possession, permanent
Declaration
income.
of title. Declaration of title.
Yes. Yes.
Declaration of title, recovery
Yes.
of possession, permanent injunction, cancellation of illegal documents.
Valued at rupees 60,200.
What is the nature of document?
My lord, transfer of, my lord, beneficial interest. And according to him, my lord, flats are, my lord, all valued, my lord. Each flat is, my lord, about 4 crore odd. And, my lord, he values the suit at 60,200.
Who is
his property is at Dale Khan Road.
Who is the executant of this document?
My lord, that is one of the authors of the beneficiary.
Who
Yes,
are from
yes,
this?
yes, yes.
Who
Kindly, my
are
lord,
the executant of this documents?
beneficiaries.
All.
All. What my lord is asking for declaration, my lord, that's beneficiaries. If my lord kindly comes to say,
And
my lord,
in favor of
other,
they are not parties.
then not all of them are parties. Not parties. Not parties. Transferees are not.
So ultimate transferees are not parties.
No. Not all of them are parties, my lord. I'll just check on that.
Some are parties.
Some of them are.
Who are they?
Check on that, my lord. I'll just check
Yes.
on that. I could check for a moment. None of them are parties.
All right. Where is the
But may I just
prayers in the plain
yes
page?
440, my lord.
440.
No, same volume. Very first prayer, my lord, is very good. Kindly look at first prayer. Kindly see C. Before that, you have a first of all, C, my lord, cannot be obtained by a trustee at all, unless he's only saying, my lord, he is the legal owner, which he is anyway. Then, my lord, kindly look at E, my lord. Very important. With my, my lord, limited knowledge of the Trust Act, I've never seen, my lord, or heard a legal principle by which, my lord, the interest, beneficial interest will now vest on the trustee. He's claiming title contrary to Section 14 of the Trust Act. Salman ke party करेंगे. Yes, my lord. F.
Recovery of possession of the flats in the schedules.
Yes.
How can this
What is
should be
this?
valued at
60,200, my lord. And just, my lord, may I just show one thing? Kindly just show. My lord, kindly look at paragraph. ওই paragraph টা দাও. না যেখানে বলেছে 4 crore 60.
But Mr. Banerjee, even going by that, the suit is before the Sevilla Senior Division, so it is unlimited. It has unlimited jurisdiction. So jurisdiction point of view, you cannot say that the trial judge
perhaps doesn't have, my lord, jurisdiction in that
pecuniary
sense.
jurisdiction bar you may not have taken because it has unlimited jurisdiction. So maybe the question issue of court fees may
my lord, come up.
May come.
But, my lord, that will also affect, my lord, the question of, my lord, whether an ex parte ad interim order, my lord, could have been passed, and whether, my lord, that could have continued, my lord, till.
That's yes, but because
my lord, because correct, my lord, that has a consequence, because, my lord, with that jurisdiction, you don't come up, my lord, before the High Court.
160. Where the miscellaneous appeal will lie.
Because this is not, my lord, I'll
ইনকোয়ারি
অন্যগুলো বলবো না দিদি সব ওখান থেকে নিচ্ছি ওটা না
সবই তো তুমি ওটা থেকে বলছো আমারও জানো তোমারও জানো আরেকটা তো হয়ে গেছে অলরেডি
আরেকটা আছে
মানে another was moved in another matter similar that has been remanded back to the appeal court.
That
So
would
that
be a
is
final
why I
order.
say, I am saying I know what you're going to say. You also know what I'm going to say.
This is a different matter. First of all, if Mr. Ray Malad wants to go into that, I will make very serious submissions on that.
I am saying
if you want to, I will make very serious submission as to how these orders are being passed. I don't want to get into that.
No, what
Yes,
do you mean by
Let's
that?
not get into that.
Let him.
No.
What does he
Let's
mean
not
by
get
that?
into that. I'm
No, I don't understand. This is
Don't
not fair.
talk amongst yourself.
How is it going to go?
Malad, so Malad, first submission. Malad, first
Please
submission.
go ahead and make all your submission.
Question of Malad declaration. Malad, question of the relief which they have asked for. Malad, according to me, Malad, has been incorrectly valued. That one of 4.60. Incorrectly valued for the purpose of Malad ensuring that Malad the jurisdiction is restricted so that Malad appeal miscellaneous appeal question Malad doesn't come Malad to the High Court at all. It's Malad to further, and if the valuation Malad is wrong, then Malad there's a question of Malad whether Malad the interim order could have been passed or not. That's only one of my points. One of my points. Malad, I am kindly Malad now Malad come back Malad to the plaint and kindly come to paragraph 3, page 389.
Paragraph 3 of the plaint.
Page 389.
Yes. Yes.
Pursuant to such ownership, plaintiff declared itself as trustee of the said property under a registered declaration of trust dated 15 November 1962, principal deed duly registered in book number such, volume such. Being at the office of the Register of Assurances, under the said principal deed, the plaintiff as trustee declared the trust upon which the said property was to be held, including allocation of specified flats to the syndicate members, collectively constituting the then beneficiaries, the then defendant number 8 herein. That's Malad, how the syndicate Malad comes in. And the holding of the land, common areas, passage, staircase, lift shafts, lifts in trust for the syndicate members, in trust for the syndicate members in proportionate shares. Plaintiff said legal title with nearby all material terms confined to West exclusively. Plaintiff as trustee that dealing with the transfer and such could be effected through a duly executed registered supplemental trust deed as per prevailing law with participant plaintiff, which is in a consistent exclusive mode. Then Malad, principal deed, paragraph 4, Malad will see Malad, there are supplemental deeds Malad which were executed, accepted by him. Then page 392, Malad will see the last supplemental deed was on 3rd November 1982. And Malad, what was happening by this Malad?
What are these supplemental deeds? What is the change which is
Yes,
taking?
change, Malad, what was happening was, Malad, the syndicate members, Malad, the beneficial interest was, Malad, being transferred. New members were coming in. So that is how, Malad, it was the.
So new trustees coming in?
Not new trustees, new beneficiaries.
New beneficiaries coming
in. How the structure was, Malad, the beneficiaries wanted, Malad, a place, the companies. So they, Malad, constituted, Malad, this syndicate. They bought a property in the name of the trust, the trustee. By conveyance, they paid the money, they constructed the buildings, and Malad, they had Malad occupying those flats. There are 40 flats, Malad, there. And then Malad, when when it was being transferred, the supplemental deeds Malad be made and Malad was registered. That happened Malad till Malad last was 82. Thereafter also Malad there has been transfers, but Malad that has not been recorded Malad so far as Malad this is concerned. We are Malad now in 2026. So this 2026, Malad, this trustee, and Malad, we have stated somewhere, there's a change, Malad, so far as the trustee, but it's a company, Malad, Dalhousie Holdings. Then trustee decided to file this suit to say, and that's the prayer E which, Malad, I was showing, to say, other declare all the transfers to be illegal, and you vest the entire title into me. And also recovery of possession so far as Malad, those.
What was the injunction sought for?
Yes, Malad. May I just Malad take Malad 2 minutes to show? I can also know, I can Malad straight away first show Malad the injunction petition, Malad, which is there, which is Malad 110 Malad, the injunction is there.
Yes, what was the relief sought for? You did not go to that. What
156 Malad with regard to Malad. Malad 156, volume 2. Oh, everything, Malad, asking for injunction restraining the beneficiaries from dealing with at 156.
So transferring, alienating, subletting, and
contrary to section 58.
And from changing, altering, substituting the identity of the person in the current situation. Yes. So the ad interim order of injunction passed to the effect. What was the ad interim order of injunction?
Malad, that's 633. That's Malad, volume 5.
Volume 5.
Yes.
Page?
Malad, page 633.
Market page number
639 is the order.
639 is the order, correct. All, Malad, with regard to Malad, my rights under section 58, different number 8, Malad, I don't know how different number 8, Malad, is. And then kindly see, Malad.
Restraining different number 8, not to act or to give effect to those third-party permissions and other things.
That's Malad, yes, continuing from 82. And then kindly see, Malad, next. Different numbers 1 to 8, their representative, respective servants, agents, all persons acting on behalf, restrain any manner obstructing, preventing, interfering with the plaintiff's free and unhindered access to inspection of.
Mr. Banerjee, with regard to the urgency, please show me the pleading with regard
Malad.
to the
Kindly, Malad, come to Malad, page 152.
Yes.
Paragraph 53.
The minutes of pleading to the
My lord, recall last supplementary deed, my lord, was 82. In prayer F, my lord, he challenges deeds of my lord 2008 and 2015. His own averment is 10 July 2025 in his petition. And he obtains an ex parte order, my lord, on 20th April 2026. And my lord, he is trustee, my lord, from 62. Who's this trustee, my lord? All of a sudden, when it's been continuing, you come and, my lord, obtain a trustee, my lord, against the interest of the beneficiaries. I'll show, my lord.
Where is the order of the trial court?
That, my lord, I showed that.
Page
633, my lord.
630.
639, my lord, sir, that ordered portion. 633, my lord, it starts. My lord, looks from, kindly read, my lord, from 633. Order 1, rulate leave with regard to the transferees.
Where is the finding on the ground of delay or urgency?
No, kindly, my lord, look at 636. Nothing. In fact, my lord says, plaintiff first became aware of the full extent of the unauthorized transfer upon receipt of reply 10 July 2025.
And
Then to
this,
show prima facie case, all the documents are only listed out. What, with great respect, what is this order?
when the suit was filed?
My lord, in 20th April 2026.
On that date, additive
Yes.
was moved.
Yes. 637, kindly see, my lord. And no prima facie finding also, 637. On careful perusal, I find the plaintiff style registered owner and trustee of the suit were established. Very well. Who's denied that? From the registered deed of conveyance dated 5th February and the declaration of trust dated 15 November 62, both being matters of public record. Further confirmed by the KMC and such. Reply dated 10 July of defendant 1 is particularly significant.
Mr. Rai,
Lord,
there is,
kindly.
subject to correction by you, there is no finding on the urgency.
Well, I'll try and show.
Because
If it finishes, well,
the cause of
I am for the
No, sorry.
I will only point out to your lordship that this particular property was acquired for the purpose of
construction and acquisition of this platoon. Both the platoons were the members of the syndicate. That happened in 1960. I am only on the issue of urgency and passing of an agreement. 62, or I should show you the logic. The agreement was first entered in 61 between my lord the trustee by Gunton's Roy's clan and our clan. Our clan meaning thereby members of the city. 1961. That particular document has two subjects. I will not show you. That is the trustee of one, the signature of the other. The main point of that particular agreement was that this property will be acquired with the money of the syndicate members, that is my clan. And my lord, they will hold only as a trustee. The beneficial
For the benefit of the beneficiaries.
Yes, and for the beneficial ownership, specifically say, beneficial ownership into the flats belongs to my lord, the members of this. Now, this happened in 61. In 62, conveyance took place. The property was purchased. They were as trustee and not for the benefit of this. The flat owners went for the thereafter after the building was constructed. 5 supplementary deeds were executed from time to time, 68, 71, 72. The last one is 1980. I am first taking from 1961 to 2026 when the 25 when the suit was filed.
26 suit was filed.
Suit was filed in 26. Governor, kindly see the number of years. 60 years had gone by since the first agreement. Since the last supplementary deed,
82.
42 years have gone by. Suit was filed. My reference client pretended not to know what is transferred. My first question is, what type of trustee? He is supposed to be, he is claiming to be.
Protect the interest.
Yes. First of all, he is claiming to be the owner of the property. And he is obtaining an order of injunction restraining even me from transferring the flats. I shall show to your lordship in the plea and the petition. Number one, this he is doing. Who is doing this? A person who is supposed to be the legal owner of the property, who had been sleeping. Even Rip Van Winkle did not sleep that long. 62 years sleeping. 42 years, not a whisper. Suddenly he woke up in the year 2025 and filed this 26 and obtained interview. But I am only questioning this. I shall take your lordship, the opportunity will come. I shall take your lordship document. Documents are loud and clear as to what right he has. I am not going to the question now. I am saying, my lord, today a party person is coming who had been appointed a trustee in 1962, who had been executing the deeds, supplementary deeds up to 1982. From 1982, there is a complete quietness on his part, and my lord, suddenly 2026 he wakes up, files obtains an interim order. Ad interim order without services. I am questioning, my lord, the jurisdiction of the trial court as also the court of appeal sustain the interim order as to how the order could have been passed. Ad interim ex parte ad interim order could have been passed without notice to the party who had been owning this property, holding this property, living in this property.
So we've got Chadda and Morgan
Yes,
Stanley.
but we've got Chadda and Morgan Stanley. Sorry. এখানে একটু দে 639 my lord has seen absolutely nothing given. এটা দেখিয়ে দিন স্যার। It's 639.
I am kindly urging your lordship that was there sufficient explanation given. Well, the law is very clear. I am not going to cite before your lordship Chadda. I am not going to cite before your Stanley Morgan Stanley. But what I am submitting to your lordship today is this, that look at the facts of this. These are glaring facts. I don't have to say anything. On the basis of his final claim, I say that no interim order could have been added to the order to the passed. Notice should have been given, affidavit should have been filed. Heaven forbid, if you did not do anything for the last 40 years, 42 years, Then what is the urgency? What has happened today?
Order one.
Which will suddenly sort of make you pick up and file a suit, obtain an interim
Order one, too late leave. And in prayer F, they mentioned the two transferees of 2008 and 2015, not made parties.
But this is the grossest of things that I have come across. I am submitting to your lordship that in the interest of justice, this particular order should not be sustained by your lordship. And my lord, this order should be set aside. Parties should be delegated to the trial court, file affidavit, and hear out the matter. Since you have
Mr. Rai, one thing, trial court, I direct them to file written objection. Let the trial court decide.
Let it decide. But Malad, on the point of urgency,
Mr. Rai,
on the point of urgency,
July is your cause of action.
Let me.
And what prompted the learned trial judge to pass an interim order of injunction 1 year after that? Almost or 8, not 1 year, 9 months thereafter, without a single reasoning.
Your lordship has heard only them. Kindly hears me, Malad.
No, I am pointing out that
they are moving it like an appeal, Malad. Let me give a submission also, Malad.
I will give you time, but this is the point which is troubling.
But I have understood.
Please show me the urgency, because
not only the urgency, Malad. First, Malad, let us see the perversity in the appellate court's order first. Let us see that, because we are here from that appellate court order first. Second, Mr. Matt.
Yes,
Malad. Now, Malad, because he has given a factual background, Malad, may I just give a short factual background, and then I will come, Malad. No,
Malad, I asked him question. I have not finished. Malad, since Malad, I asked him, I am saying, Malad,
only one thing, Mr. Banerjee, because I stopped both of you. I stopped you. Then Mr. Mitro wanted to add something.
Malad, let
only
them
on the ground of.
Yes, urgent.
On the ground of
urgency.
Yes. After that, Malad will hear.
Whether you have a merit or
yes,
not, let that be decided.
Malad, yes.
That order could have been passed.
Even if you satisfy those 3 legal tests,
Malad,
for passing
on the ground of urgency,
injunction, for the purpose of passing an interim order of injunction, you have to satisfy one more fact.
Malad, I will.
So I am at this stage on that.
Malad,
I can see if you have satisfied, then I will go to the.
Yes, I will do.
Tests I can call upon Mr. Banerjee.
I will do that. I will do that, Malad. Malad, I also don't mind. Let it go back, but with Malad only one rider. Your lordship is going to vacate the interim. I don't have a problem. But Malad, they will also not transfer. Malad, they cannot have a premium. They cannot have a premium. That is why I'm saying Malad will have to see the facts.
Without influenced by anything.
No, Malad will have to see the facts.
But Mr. Rai, if Malad, I restrain them, that would be in an indirect way injunctive.
Because Malad, today,
so I can, if they have filed the written
Malad, that is what was precisely said, Malad.
I can direct Mr.
It's on the 12th of August.
Yes, Mr.
It's
Rai.
Fixed.
Mr. Rai, lease pendants is also there.
Malad, lease pendants again, Malad.
Lease pendants is also there.
Malad.
So if in the meantime they do anything, that will be hit by the doctrine of lease pendants. That is already
Malad,
there.
that is something which we are really worried about. I'll point out why, Malad. Because Malad,
So,
today,
12th of August, Mr. Banerjee,
it's a hearing.
filed a written objection.
It's the appeal hearing is on 12th of August.
Instead of the appeal hearing,
Yes.
Mr. Rai, only one.
I don't understand.
Appeal hearing
Yes.
will be against ad interim.
Yes.
So let the main temporary injunction be heard out. What's the difficulty?
But it can be heard whether the interim order stay, Malad. That's the question. Whether Malad an interim order will be vacated or not, Malad.
Mr. Rai, only one thing. Mr. Banerjee, have you filed your written objection?
No.
In the
trial court.
Mr. Banerjee, your stay application.
In the appeal, Malad, they have not filed any written objection.
I'm not on appeal. Let us don't fight on the ad interim. Go back to the temporary stay.
Malad, kindly set aside the order, Malad, and then Malad will go back.
And
order has to be set aside.
No,
It can't be, Malad. He can't, Malad, have a premium.
Thing, Mr. Banerjee,
Who's having the premium?
You have filed your stay application in the appeal.
Yes.
And you have also filed the civil division application. So I think
is from the.
You will not take much time to draft the written objection to the injunction application, because all materials are here. So you can file your written objection within a week. So I can direct on 12th to take up the hearing of the temporary injunction application.
Yes.
Malad, only
How much time you
Malad,
will
only if the order is set aside. Malad, otherwise, kindly do not.
Then I'll argue.
Malad, then he's succeeding.
No.
I'm succeeding.
Today, Malad, he has obtained from court.
I'm considering that. Can you do that? Can you file your written objection? 12th is the next date fixed.
12th is in the appeal court, Malad. In the trial court. 31st August.
So 31st, so you are getting time. So if Mr. Banerjee files, how soon? 18th, 19th that week, we can give them 4-5 days.
Yes,
I shall file.
we'll file it.
Because basically stay application contains everything. So you can now cut, copy, paste. You can
We'll do that with no difficulty.
Yes.
But
We shall file it within 7 days time. Implementation.
Yes, that I've not heard Mr. Rai. So with regard to the
what is this?
objection, now I have to, because before vacating, I have to hear
Yes.
Mr. Rai, because he has not
Let him
opened this.
satisfy on the urgency ground. His
He
own
has
pleading
not
is 10
opened
July
this bound.
2025. His own pleading is 10
Mr.
July.
Rai, how much time he will take?
It'll take some time, 20.
I'm
It
asking you.
another.
The question is, how do you show urgency? I've shown 10
Like you have shown that there is no urgency, I will also need to show that there is urgency, Mr. Banerjee.
How much time will be taking?
Sorry.
Learned Advocate Jail is.
I know, I am assisting him in that matter, my lord. Well, kindly keep it
also in the next matter.
Well, kindly keep it tomorrow, my lord. I'll be here.
How much time? That is what I.
20 minutes. Monday, nahi.
That I have fixed. Your matter I have fixed long back. I do not know.
Well, kindly keep it tomorrow, my lord.
Where is your other side? Yes, madam. What do you say?
So they don't want to do the matter. Kindly continue with this. It is quite
not that.
understandable.
It's not that they don't want to do this matter.
They're letting us do the matter.
Next week. Next week.
আরে দাদা আমি আছি ওই ম্যাটার আমাকে তো আমার সিনিয়রকে সেটাও বলতে হবে না
আজকে কি অবস্থা দেখুন তো
একদমই নিলাম
come section.
My lord, kindly keep.
Trust Act to aniye neben.
Kind of document and the law.
In.
Right to transfer beneficial interest. The beneficiary, if competent to contract, may transfer his interest, but subject to the law for the time as to the circumstances and extent in.
According to you, this cannot be injuncted.
Yes, number one. And number two, my lord, kindly come to 14 section 14.
Section
14.
Section 14. Section
Yes,
13,
not to set up title adverse to the beneficiary.
and this is exactly what it's doing.
Yes.
And my lord, interim order that is being sought for, that I am not going to transfer the flats.
So according to you, your beneficial interest is being affected by that.
This is those short.
Yes, sir.
My lord, before I start, my lord, your lordship will kindly give me 5 minutes so that I can deal with what is the case all about. I mean, we've heard from my learned friends about my case. So let me also try and explain
Yes,
what
I will hear from you.
No,
your
my lord, that
case.
from there the urgency is also going to crop up, my lord. I'll point out that. My lord, many things have been.
Two things before you start.
My lord.
You may have your urgency.
Yes.
But first thing is that whether that has been considered.
Yes, it has
by
been
the
considered.
trial court and
Yes, sir, both the courts.
finding has been
Yes,
recorded
yes.
on the urgency.
Yes.
Already.
My lord, the word urgency might not have been used, but yes, it is there.
Word urgency
It is
may not
there.
have
It
been
is saying
used,
it
but,
will tantamount to multiplicity of proceedings, and again further transfers would need to be stopped. Well, that is the
Please
finding.
keep in mind while addressing.
Yes, well, I'll say that. Well, may I just point out what I'm going to submit? First, I'll give a very short synopsis of my case. Next, I will take a legal point as to what is the scope of an appeal from an ad interim order, and also, my lord, how much your lordship will go into it. That is another point. And then I will only try and establish, my lord, whatever points my learned friends are taking on the point of urgency. I will just have to show your lordship, because what they are saying today, it is not expressed in the agreements. It's completely contrary. First. And second is that, my lord, in their appeal, they have taken out, my lord, a new set of documents from where we find the syndicate, which is a association of the beneficiaries. They are taking transfer fees and saying that they have the right of transferring. So, my lord, these things, my lord, need to be told to your lordship. Now, my lord, what we are saying, my lord, we are a trustee, definitely. My lord, definitely under the Trust Act, my lord, there is a settler. According to them, they are the settlers. Has to be. Because they say they got the money. The importance of getting the money stops there once the trust deed is formed. Because then the property of the trust vests in the trusts. The trustee, sorry. And the beneficiaries remain with the beneficial interest. Now, what was the beneficial interest? The beneficial interest in the Trust Act, well, if your lordship wants to see, I can show, is the possession of each of these units. Malad, section 58 of the Trust Act cannot be read in isolation. It says, in inclusive of the law enforced, Contract Act is not thrown out of the window. If you have contracted in the trust deed in such a fashion, you'll be bound by that. Now, Malad, what happens? They were aware of this. Therefore, from 62 to first, Malad, just gives you a moment. Malad, I might get the dates wrong, Malad. 68, 69, 71, 72, 82. These are all supplementary deeds of trust. And why? Let us understand, Malad. Just by saying a lot of things cannot be. In all these, Malad, the trustees acknowledge, the beneficiaries acknowledge that there is a need for a supplementary trust deed. Why? The reason is that the trust deed did not contain the name of these beneficiaries to whom it is being now transferred. So they have to be also a part of, become the beneficiaries. So therefore, Malad, these were registered deeds. And there they acknowledge that it has to be made. Till 82, Malad, they have made. And who has made? It's the same person. The petitioners are there. Now, petitioner number 2 is keeping all quiet now. But it has come out on record now from their pleadings also
that they've disposed of all the flats. All flats disposed of without any supplementary deed. But from the first supplementary deed and the fifth supplementary deed, their shares had increased. And for every unit they got, they themselves entered into the supplementary deed of trust. So it was the practice, it was what the trust deed required all the time. And now they are saying, not only that, Malad, the trust deed clearly says, Malad, these have not been shown, obviously, Malad, they would show it, but why the urgency? I'm just pointing out. The trust deed says, Malad, they are saying the beneficial interest in respect of the flat, no problem. Malad, transfers of car parking are being done by these conveyances on the ground of transferring of beneficial interest, which admittedly are lying with the trustee. And these are all unregistered agreements. So, Malad, today what is happening? They are transferring even the trust property per se. Malad, I don't have a problem. If they want a dissolution, they can. But today we are not there. We can't just say the trustee is not working for 60 years, rip and winkle. I do appreciate. That does not overcome an illegality which is continuing. Today, Malad, when they come up, we find in 2025, Malad, we have been continuously asking them, tell us, give us the details. We have not yet got the details. We have not yet got the full details as to who these have been transferred to. So the question is, Malad, if there is a case where, Malad, an illegality is happening, which is an admitted position because they were parties to the original trust deeds and the supplementary trust deeds, and the subsequent transfers are not by way of that. Malad, that itself shows that there is some prima facie case. Now I'm on the prima facie case. Only on the prima facie case. Now let us consider the balance part, Malad. Malad, what are we saying? That do not transfer to any third party. I'm not saying you do not remain the beneficiary who was the beneficiary. I'm not saying that. I'm saying you beneficiary do not transfer. Let the court hear it. Let the court decide whether a supplementary deed is required or not, because I've shown that it was required. So if it was required, you have to show why it is not required today. So there comes the balance part, Malad. If it is required, Malad, then what happens, Malad? Then if they transfer, Malad, lease pendants is a very, Malad, it is not a substitute for an injunction, Malad. With humility, I say, Supreme Court very recently also says that. In a Order 1 Rule 10 application, Malad, that has also been said so, Malad. So the point is, Malad, the urgency now. Malad, the urgency is writ large today. Because now in the appeal court, this document has come out, which is also a part of your civil revision application, where they are saying the trustees that by resolution, it is only, the syndicate says by resolution that syndicates will take steps to transfer all these flats and approving the transfers. And each of the two deeds which you've got, Malad, includes, Malad, it will also show, Malad, how strange and cleverly it has been drafted. In the habendum portion, Malad, they do not say that it's only beneficial interest. All that flat. And at the recital, they say, yes, I'm a beneficial. But these are very, very, Malad, cleverly done. But the point remains, what am I trying to say? That if you have to transfer, you'll have to change the beneficiary list. That was being done, acknowledged by you, that needs to be done. Today, if there is any further transfer, well, let us say those two first agreements, Malad, I might have been late. But what happens today, Malad, if they're again going to transfer? I am under that apprehension. At that point, I was also still under the apprehension that they will transfer again. In this prima facie case, Malad, and where I'm showing that yes, they have been transferring, Malad, it creates an urgency immediately. And that is what the courts have held, these two courts. Not judgments, Malad, these two courts have held, that it will tantamount to a multiplicity. Because it shows that there is a problem here. Malad, may I now take your lordship through the two orders? Because, Malad, today we are not, as far as I understand, an appeal hearing before your lordship. So your lordship will kindly see, keeping in mind, Malad, that the
scope of the suit.
Not only that, Malad, the appellate court, Malad, is also bound, Malad, several judgments of your lordship's court with regard to a miscellaneous appeal. Because they have come up from a refusal of a stay. We are only on that, Malad. Malad, I can, if your lordship wants, you can take up the appeal here and we can decide. But that is not what we are doing here. So we have to show that the appellate court was wrong in not staying. First point, my lord, if it was stayed, my lord, tantamount to granting of the appeal itself. And I'm covered by judgments, my lord, I'll be referring to that. Now, from there, your lordship has been approached. My lord, with humility, I say, my lord, your lordship will try and find out whether that order is perverse or not. So now, my lord, may I just take your lordship first to the appellate court, and then I'll show the trial court also, my lord. accept করছে না দেখো কোথায় ট্রায়াল কোর্টে কোথায় দেখো আগে ট্রায়ালটা দেখো না আগে অ্যাপিলেটটা দেখাই the one which is under your this challenge, I will show that first. May I show the appellate court and then I'll show your lordship. The appellate court order for the certified copy. Oh, my lord, last, sorry, yes, volume 5, man. Once in a while I'm forgetting. Volume 1 রয়েছে তাহলে ঠিক আছে Mallet has marked volume 1, Mallet.
Are the certified copy?
Mallet is looking at the certified copy. Mallet. Mallet kindly sees, Mallet. Order number 5. Record is taken up. Mallet kindly comes. হ্যাঁ স্যার আমি একটু আপনারা কি বলেছেন একটু আপনি তো বলেননি ওনারা কি বলেছেন একবার দেখিয়ে দিই আমি একটু তারপর বলবো material question which comes up মানে kindly the second page মানে
yes
material which comes to the consideration at this stage whether the finding of the trial court based on the facts pleaded in the plaint and the injunction and the documents submitted in support thereof to avail ad interim ex parte is perverse or supported by reasons within the scope and ambit of order 39. Now my lord kindly comes to the next page. The learned court.
Yes.
Now, my lord, the last part of it, my lord, the learned counsel quoted para 61 of the injunction application. Well, and contends that these are only facts pleaded to show urgency involved in the matter in order to avail ad interim order of injunction, which according to the learned counsel are not sufficient to grant such relief ex parte, without giving any opportunity of being heard to the appellant defendants. It is submitted by the learned counsel to the appellants that appellant are in possession of the suit property. Malad, this I don't think is the right point, Malad, because Malad statesman has already transferred its entire property. That is on record, which would be evident from clause 2 of the trust deed relied upon by the plaintiff before trial court. It is submitted that the reasoning of the trial court is based on a complete wrong appreciation of the materials placed before trial court with regard to the ownership and possession of the suit property. Submission of the learned counsel that the operation of such order is required to be immediately stayed, serious civil consequences depriving the legitimate rights of the defendants able to enjoy the property. In support of such contention, Malad, 3 judgments are shown. Per contra, plaintiff submitted that the learned counsel has elaborately discussed the factual and considered the documents placed in order to come to a logical finding of grant relief of ad interim. Then, Malad, page 7, Malad, thereafter, Malad, we have also said, Malad, in page 4, Malad, learned counsel submitted that the operation of the interim order state the appellants will dispose of several properties, thereby rendering the relief sought in the suit itself entirely frustrated. It is further submitted that if the order of injunction subsequent pending of the hearing, the rights and interests of the appellants will not be prejudiced in any manner. Then, Malad, Choksi is being referred to. Then, kindly sees, Malad, I've heard the submissions.
Yes.
Made by the learned parties. I've also considered the citations. It is an undisputed position that the plaintiff filed the title for declaration injunction before the trial court, claiming to be owner and trustee of the suit property, seeking interest such consequential relief. Upon consideration made in the plaint and injunction along with the documents submitted, pass the ad interim order. Malad, the ad interim order is set out, which I'll again read, Malad, once I finish this. In order to come to such finding, trial court considers the following documents. So, Malad, these documents are all discussed, noted. Then, Malad, on bare perusal of order passed by the learned trial court, it would appear that the learned trial court category dealt with facts pleaded by the plaintiff and considered as many as 18 documents in order to come to the prima facie finding about the plaintiff's title as registered owner of the property by virtue of the registered deed. Learned counsel also, I'm not reading that. Learned counsel also considered the reply of 10 July 25, defendant number 1, whereby the defendant purportedly admitted to have limited beneficial interest and confirmed that all 7 transfers were effected solely on the basis of management committee approvals of defendant number 8 without any reference to participation of the plaintiff as trustees. This is their letter, my lord. Learned trial court appears to have also considered facts, pleaded, and documents placed with reference to execution of 2 unregistered agreements in respect of the 2 flats. Well, these 2 I will show you, Lordship. I said I need to show this. And the status and the rights of the parties as a consequence of such transfers, especially in the context of claim of the plaintiff as the sole registered owner and trustee. Trial court separately dealt with the facts avoiding the injunction absence with reference to irreparable loss and injury, chance of creation of encumbrance on third-party interest in respect of Schedule B property and the possibility of multiplicity of future proceedings in case of refusal of such injunction. The grave urgency involved in the matter for granting ad interim appears to have been considered in the context of the possibility of unauthorized dealings with the property by the defendants. Malad, I'll show para 61. Malad, I'll have to read para 61 of the petition. Malad, I'll show that. But let us go through this first. Learned trial court appears to have considered the materials in the entirety with reference to urgency pleaded in the injunction application and passed an ad interim injunction considering the basic parameters such as the prima facie case, balancing income and irreparable loss and cited reasons support that. Decision rendered in the case of subsequent redevelopment by Choksi clearly established this conclusion reached by trial court based on the materials is found to be possible for a reasonable man. There is no perversity, and that the another judge may have read the evidence differently does not make the finding perverse. Applying the ratio of such decision in the given factual nature of the case, is clear that the trial court's finding apparently does not suffer from perversity. In view of such reason, judgment cited on the behalf of the appellant do not come to any aid to support the case of the appellant at this stage. To avail an ad interim order of stay of the operation of impugned order, especially when it's apparent in the face of the materials considered by trial court that there may be transfers of some of the properties with the subject matter of the suit.
Yes.
Accordingly, prayer made is refused. So, my lord, the trial court has come to certain observations. I'll show. Appellate court says, yes, I've gone through it, and I also uphold, and I'm also in synchronization with that finding, which is at the very last, that there is transfer of some of the properties where the subject matter of suit property can again take place. So this is my urgency, and that is what is included in 61. Malad, I'll take your lordship now to 61, and then I'll take your lordship to the trial court finding. Malad, kindly comes to para 61. Malad, page. Malad, just give me a petition. Malad, kindly comes to volume 2, page 155. Malad.
Yes.
Yes. Malad, they also admit that there's a pleading, but it's not sufficient. That's what they're saying. Malad, kindly see 60 is the balance paragraph and 61, Malad.
Yes.
The plaintiff suffers will suffer irreparable injury if ad interim and temporary is not granted. The suit property comprises 34 flats of substantial commercial value in a prime location. Each additional dealing, subletting, encumbrance or creation of third-party rights in respect of any flat will give rise to further complications, including further unregistered agreements, further sub-transfers, further use of the trust property as registered officer entities, all of which will be incapable of being undone by a money decree alone. The plaintiff has already discovered a chain of at least 7 disclosed unregistered transfers occurred in respect of the defendant number 1's flat. If the defendant is not responding, this chain will grow further pending the hearing of the suit, making recovery and administration of the suit property progressively difficult. The harm caused by further unauthorized dealings is in immovable property is very nature irreparable. Now, Malad, kindly appreciates, Malad. I have come across 2 deeds in 2025. And what do I say now? I say that they might be again dealing with. That is my apprehension. And why is that apprehension? It's the apprehension on 2 earlier deeds. Malad, if I am told that I'm late, it might be that I'm late for those 2 deeds. But I want to prevent similar deeds. And obviously, Malad, if they come to be given notice, then immediately transfer. So that's my urgency. It's not that I cannot come before your lordship with an urgency saying that I apprehend that this is going to happen. And precisely that has happened. In their appeal, they're saying that. In their appeal, my lord, they're specifically saying that we have dealt with it. And still, my lord, we have given letters, they are not giving they are not disclosing the names. Now, my lord, let me go back to the trial court order. Just give me. Come to the order of the trial court. 633, my lord.
Yes.
Volume 5.
Yes.
And after I read this, my lord, I'll try and argue, my lord, the scope of perversity, my lord. Wrong and perversity, my lord, different things, my lord. I'll just try and assist your lordship. Kindly come 633. My lord, your lordship has got 633. My lord, the third plaintiff asserts. My lordship got that one. Yes. Plaintiff asserts that it is the. My lord, may I take your lordship first to the urgency part?
Yes.
And then I'll take, my lord, I think that will be better, my lord.
Yes.
My lord, kindly. My lord, kindly comes.
Just come in one. Just come in one.
My lord, kindly comes to page 5. At the bottom of the page, my lord.
Yes. The two registered.
Yeah, unregistered. Unregistered.
Sorry, unregistered.
Let us stop the registration, my lord. That is now, my lord.
Yes.
Two unregistered are placed on record dated such and such in respect of the flat number such and this. Well, these we got from the ROC because these companies were dealing with showing those places as their registered office. Then we come to know that this is what is happening. So, Malak, that's why we got this in 2025. Then clause 13 of the 2015 agreement acknowledges the plaintiff's role and the trust structure, while clause 8 of the 2000 agreement explicitly acknowledges that the registered supplemental deed of trust with the participation of the trustees was required to complete the transfer, which admittedly was never executed. Both agreements are unregistered and executed on stamp paper ₹100, rendering them void and legally ineffective or under section 54 and 17 of the Registration Act, regardless of the constitution and stated therein. Furthermore, defendant number 8's withdrawal of the fourth self-assessment form submitted at the KMC itself an admission. The said document was not a valid or authorized filing on behalf of the plaintiff. But before the KMC, Malad, there was this person from the Minto Park syndicate who has been trying to say that he's the trustee. Then criminal cases started. KMC does not accept that and acknowledge them. As a matter of fact, they filed a writ petition where no orders have been passed on this point that show your that you have the right as a trustee. Nothing has been shown. So this was another ground that this person was trying to show that he is the trustee of the syndicate. Now, Malad kindly comes. Learned advisor plaintiff has referred in terms of the decisions of honorable court. Malad, the decisions are cited. Malad, I'll straight away come to the last paragraph in page 6. Malad, see the prima facie case.
Yes.
Malad, just one paragraph, one sentence above. At this prima facie stage, Malad, I've seen that. Malad.
Yes, yes.
The person in occupation, though unregistered instruments, cannot be said to have any recognized right of title to register the claims of plaintiff as the sole registered owner trustee. Balance of them favors protection of the plaintiff's title during pendency of the hearing of the suit. Prima facie case is therefore clearly established in the documents themselves. Balance is entirely with the plaintiff. Plaintiff is the sole legal owner and trustee of the suit property and has been wrongfully excluded from access to an administration of suit property. Granting the injunction merely preserves the status quo and does not require the defendant to do anything beyond refraining from further unauthorized dealings. No injustice is done to a party by restraining from that which it has no right to do. Refusing the injunction, on the other hand, would allow the defendants to continue creating further third-party rights, entering into further unregistered arrangements and dealing with the trust property, as if they were absolute owners, thereby rendering the ultimate relief in the suit illusory. Any further dealings, encumbrances, or creations in respect of Schedule B will give rise to complications including being undone by a money decree. The plaintiff has already submitted a chain of at least 7 disclosed unregistered transfers and registered flats of the defendant number 1 alone. The said property is unique and immovable. Unique. What do- The harm caused by continued unauthorized dealing is immovable, is of very nature irreparable, no amount of damage will be. And the next paragraph, I'm also saying sufficient cause for the plaintiff to move ex parte. The plaintiff has given reasonable apprehension. If notice be given with the defendants, it may further accelerate dealings and transfer resources, suit flags, creating additional third-party interest, and introduce further complications that would defeat the very relief. This is a case where title is clear, the admission of the defendants on record. And I'm sure it's talking about the supplemental deeds of trust, Malad. And apparently, and delay will defeat justice.
Yes.
This is therefore a fit case for immediate interim injunction.
So according to you, the documents that were placed were considered, and being satisfied with the urgency, the learned trial judge has passed an order of
Malad, let us understand it this way. Malad, let us, for the time being, let us have not asked for any injunction vis-a-vis the documents on record. But on the basis of that, I say that there is apprehension. Malad, let us now consider from that factor whether that can be an urgency or not. Definitely that can be an urgency. Because, Malad, I have been communicating, Malad, I have not been able to show all the documents. There were communications and they were always refraining from giving the particulars.
How much time it will take?
Malad, I don't know whether I've been able to show the urgency part, Malad.
So you can make your submissions, urgency part, and according to you, you'll be citing some decisions on that scope of the miscellaneous appeal, whether at that
yes, Malad,
stay can be passed.
Yes, Malad, that I will.
That is what I'm. How much time we will be taking?
20 minutes.
But keep it because the contempt
I'll keep it tomorrow, day after. Saturday. Oh, day after Saturday, sorry. But last Saturday I worked.
Tomorrow, working is Monday. Yes. We take it at that. Mongolbar ki avastha ache? Let me see what this.
Submission, even Mr. Banerjee is not here on 13th and 14th, but somewhere in between it could be Monday. I think it will be better. Schedule better too. Use it
13, 14 I'm not.
And 11, 12th I am not there. I'm sorry. After that I am here continuously. Yes.
Yes. I'm trying to, because tomorrow from 3 p.m. some matters, other matters are fixed. That is why the immediate day is Monday. It can be taken.
Monday, Malad.
Tuesday, subject to your convenience. Monday te এই বইটা দিয়ে দিন।
Grateful.
যদি একটা ট্রাস্ট একটু বেয়ার একটা ট্রাস্ট ম্যাটার্স, ওই ম্যাটারটা একটু আগে ডেকে দিন।
Mr.
This is first time or upon
No, Lordship, notice has been served upon me.
Oh, that matter.
Now, Lordship, the difficulty is because why the order has not been complied with. Lordship, the alleged contemner, his
only for the purpose of securing the government money. In case of enhancing the quantum, if any additional bid requirement, bid amount is required, because for a couple of weeks ago it was communicated to the ADM that to communicate as to whether any additional bid security is required or not. I believe the petitioner will not stand in the way for.
I say, Milord, today these questions, Milord, cannot crop up.
Who is appearing for the additional district magistrate?
Lordship,
So Niranjan Bhattacharya must be.
Must be presently, Mr. Bhattacharya will appear.
Join on Monday. He will join on Monday.
No, Lordship, I'll.
Not here.
He will join on Monday.
No, Lordship, kindly.
His junior.
Lordship, kindly grant me 2 weeks time. In the meantime, Lordship, the portal will be.
I will, Milord, I will cannot reap the benefit. Today, Milord, 12th March 2026.
I know there's a.
What can be, I can issue a
Monday,
rule. I can
Milord,
issue a rule.
No, kindly.
That might not help you.
But Milord, no.
Lordship, subject to Mr. Basu's conveyance, Lordship.
The junior of Mr. Bhattacharya, who
Joyita Dhar Chaudhuri, she usually appear. I'm not aware. I believe.
Boss, can you ask your juniors to call Ms. Joyita Dhar Chaudhuri?
Yes. I will inform him in writing.
Please ask her to come.
Yes.
I'm passing it over to Passover phone. Please ask her to come.
No, I believe it's not a party.
No. ADM is not
a contempt. Lordship, instead of passing over, Lordship, kindly, subject to approval of Mr. Basu, I'll take 2 weeks time. In the meantime, if no response come, Lordship, we will upgrade the portal, notifying the required quantity.
2 weeks it will be.
Absolutely unacceptable.
I'm keeping it.
Next Thursday, Lordship,
I'm keeping it.
next Thursday.
I record that here.
Because the ADM is not party, so.
ADM is not a party.
দেখি ফাইলটা দিন এইটা Yes, call the next matter. Taken on record.
Well, in this matter, my Lord, Vivekananda Tripathi is appearing on behalf of the petitioner. Well, due to his illness, he has not come to court. Only I am saying not today.
Who has not come?
Petitioners, advocates, Vivekananda Tripathi.
You are paying for time.
Paying for time, my Lord, because he, due to his illness, he has not. But direction was that to.
An accommodation has been sought for. Or any advocate who is assisting Mr. Bhattacharya. Oh, you are appeal. All right, then no problem. Yes. Yes, call the next matter.
Madam, we are for the respondent. I am for the petitioner.
Yes. What is this?
The affidavit of service 1, 2, and 3 services complete. 4, 5 refused. And my lord, the added
good service.
Yes.
Yes.
My lord, I am just stating.
What was the direction?
My lord, your lordship passed the order on 6/12/2024, my lord. But this is the report, my lord. And thereafter, my lord, the DI
complied with.
No, because appeal is pending, my lord.
Oh, appeal is pending.
Yes, my lord. The appeal, my lord, they prayed for an interim order. It was refused. My lord, the school authorities have filed an appeal. This is the order, my lord. If your lordship kindly peruse the order. My lord, interim order was prayed for,
appeal
it
has-
was turned down.
When the appeal has
I am
been,
going to retire, my lord, in October.
but the appeal,
My lord,
the appeal has been
by
filed.
showing the pendency of an appeal, where, my lord, they failed to obtain an interim order.
But the appeal has been filed on
They
19th
cannot
March
frustrate this honorable
2025.
court's order.
So interim order has been refused.
Yes, but kindly seize
Then
this
you have to
order.
comply with.
My lord, kindly seize this order.
But kindly, as my lord,
Then
my
mere
lord, as-
pendency
Specifically-
cannot operate as a state.
Specifically.
If the interim order has been refused, then you have to.
I am going to retire, my lord, in October. This is an order of 2024.
Commission of School Education.
হ্যাঁ, স্কুলে ঢুকেছে এরিয়াটা।
Yes.
My lord, kindly comes to your
Not
lordship.
with me anymore, your lordship. It is with the
Kindly comes to your lordship.
case 36, your lordship,
Page 36 of the.
of the contempt application.
Yes.
My lord, here, my lord, my lord, we have already
Directed to comply. That is
yes,
there.
we have directed the Commissioner of School Education, directed the school to comply with
Kindly
the
comes
court's
to
order.
page
your lordship,
21 of the,
areas,
your lordship's
salary
order.
and everything is upon the school to decide
Yes.
and forward to the
There was a
DI.
specific direction upon the DI. Kindly comes to page 21.
My lord, DI.
Paragraph 24. Your lordship's express order.
No, the disciplinary proceeding was set aside.
Yes. And a direction of your lordship was to allow the school to allow him to join the duty and thereafter release all his salary and benefits.
Paragraph 24 of your lordship's order, page 21. DI was directed, my lord, to release the entire payments within 6 weeks in 2024.
Now it's upon the school.
Upon the school.
School,
And the
school has
DI
intimated, man, that
kindly seize the order. The concerned DI of the school shall release the payments. The school,
Payment has
the
not been
school, he
released.
is the headmaster. No, that is like the school. Well, now, the petitioner was the headmaster. He had to face the disciplinary proceeding. That was, my lord, set aside.
Well, the school is to send the requisition to the DI.
Everything
and on
is
that
done.
requisition, DI will work. Right?
Everything is done. DI service has also been effected upon the DI.
School has
Upon receipt
intimated.
of the same. So
School has
everything
intimated.
is to be initiated from the end of the school.
School, my lord. The
So
school
unless the
has
school
intimated,
does,
my
how
lord.
the DI can be.
Yes, my lord. The school has
I have
intimated
served, my lord,
that
the
appeal
all
has
my lord,
pending.
now there is no managing committee.
Yeah,
When
appeal
your
is
lordship
pending.
passed the order, my lord,
Before division
there
bench.
was the managing committee. I served all the.
Man, this is the order, my lord. This is the school has intimated the DI.
You are
I
from
mean,
who?
we have the state, my lord. The
That
commission.
was the state.
You are
The
from
state. We have the state,
Now
my
the-
lord.
So the school preferred an appeal. School.
Yes.
The appeal was.
Appeal is
interim
pending,
order
my lord.
was. Appeal may be pending. Interim order. There is no interim order.
interim order was refused, brother. Interim order was refused. They
Interim
prayed
order
for.
was refused.
Yes, they prayed for.
Whom have you implemented as contemner?
My lord, I have implemented, my lord, the DI also.
President, teacher in charge.
Yes, because he was the teacher in charge when I was, my lord, thrown out.
Now who is the
Now, my lord, it is entirely all the schools, my lord, the managing committees have been, my lord, dissolved. My lord, now the administrator, new administrator has come.
You have to serve the administrator, otherwise.
That, my lord, my lord, if your lordship directs, my lord, as administrator, I shall
the,
serve. But yes, lord.
When
But so far as DI, my lord,
Mr. Rai, learned advocate, appealing for the petitioner.
Here, my lord.
Well, matter to
Please
appear.
add him, don't delete those.
No, no. My lord, matter to appear, my lord.
Addition to administrator. Copy of the supplementary affidavit shall be served upon the administrator.
This is my application.
Yes.
Initially, Your Lordship, on 9th of September 2024, Your Lordship directed the alleged contemner initiate a proceeding and under Act 30 of 2013 and complete the process within 4 months. It was communicated on 26th of September 2024, 24th of September. Then, my lord, subsequently they filed an application for modification of Your Lordship's order.
Direct purchase.
Direct purchase. That kindly turn to that order dated 27th of November 2025. Your Lordships categorically said that the applicants in can number are directed
within 4 months.
Possibly within a period of, if not done, then Your Lordship's order dated 9th September will
revive.
So nothing has been done.
Lordship, in regard to this matter, I do not have any instruction in regard to this matter, Lordship. I am led by Mr. Debashish Basu in this matter, Lordship. I am led by Mr. Debashish Basu in this matter, Lordship. Kindly fix it after a week, Lordship, so that I can get the instruction from the concerned department, Lordship.
And my lord, one more thing I must.
Mr. Pan, now they have to take
No.
instruction.
I am not on that. Only another difficulty is this, my lord. The new incumbent has joined. So let her take the instruction.
You can add the new incumbent
Yes.
as a party.
Kindly.
Mr. Pan Lanet.
Not have the copy also. Sip and copy is also not with that.
Copy of the contempt application.
Yes, sir,
Mr.
Lordship.
Pan, please give us.
Can you record that I am here and I am serving?
The copy of the contempt application has been served. Yes, Mr. Banerjee. Next. Yes. Who is appearing? State. Yes. Who will represent the state? Yes, madam. You are representing the state in land matters.
Yes,
Yes. So you have to appear for the contemner in land matters also, collector.
Lordship, but I have no information regarding the state, Lordship.
You have no instructions. Now you will get instructions. Yes, Mr. Pan. Please give her a copy because otherwise.
There and now I am giving. The copy there.
Yes, this is what matter.
There is a direct purchase policy. Kindly, Your Lordship, order dated. My lord, at.
Yes, what is your stand on direct purchase policy now?
Lordship, I have to check, Lordship.
No. Without going to the content application, what is your stand on direct purchase policy?
I have to
I have to collect instruction, Lordship, because I don't know regarding.
I'm asking you in general, what is your stand, not in this matter?
In general.
Yes, on direct land purchase policy. You are proceeding on that, or you have taken a.
No, Lordship. Some places we are proceeding with the
Direct purchase policy.
Lordship,
Uh,
with the consent of the parties, obviously.
in view of the change which side? This side, that side? Not that side.
This is arising out of civil division, not a land matter.
Civil division, yes, civil division contempt, what contempt?
This matter, my lord, schools for declaration of tenancy right, in which the application was
What is
filed.
the order?
Order, my lord, I'm pointing out. Direction was passed from repairs. That was challenged by the petitioners, contemners hearing before your lordship. Your lordship, while affirming, my lord, they made an undertaking before the court that they will not repair the premises within a period of 1 month. Recording that undertaking and directing them, permitting them to do the repair work, it was disposed of. So on the basis of
No, they have not done.
We have done, my lord.
No,
We have done,
they have not.
my lord. We have done. Well, I will show, my lord, from the order. We have done, but they have not unlocked the, my lord, the room, my lord, so that we can.
How could you do?
No, no, my lord. That was the repair on the roof, my lord. I have done the upper portion of the roof, but my lord, then the inner portion of the room we cannot do not, because my lord, they have not.
Is it believable? After I come to the court, get an order, then I lock him out.
That is
it believable?
No, no, that the my lord, the roof, the order was that we have to repair the roof. We have done the reparation of the roof, my lord. We have done, but my lord, they have not opened the padlock so that we cannot do repair in the, my lord, inner portion of the room. That is my
Let
instruction.
them do. I shall kindly but keep it written after 4 weeks. I'll give you access. Let them do it.
Yes,
I would not.
This is I have
believable,
my-
but after not coming to the honorable court, after
I can
recording
show
this
my lord
undertaking,
next day.
filing a contempt, I will not
It's
open the
very
door.
difficult to believe.
Unbelievable.
It's very difficult to believe what you are saying. It's very difficult to believe. If you want, I can ask you to file affidavit, but if it is on false statement on affidavit, your client will face the consequences. It's very difficult to believe. A person who wants his property to be repaired by you, he will not give you access. It's very difficult to believe.
My lord, next day, my lord, kindly please state it, my lord, there is a, my lord, commissioner report after this order was passed.
Yes, what is the repairing? How much time it will take?
That I have to take inspection, my lord.
Yes, Mr. Banerjee, how much time it will take?
3-4 weeks, my lord, building has become dilapidated. 4 weeks, they can do it within 4 weeks and come back. I'll give access.
The learned advocate
Yeah.
Madam, for the petitioner in this matter.
You are appearing.
এই তুমি দাঁড়াও না। And new incumbent.
New incumbent has joined. Here also.
After fourth, everything has changed.
Acha. New incumbent.
In this matter, I am for the petitioner, my lord directed me to serve copy and service along with the file has been misplaced, my lord. Kindly, my lord.
You have to serve again.
My lord.
You have not served.
No, I have served, my lord.
Otherwise, the contemners would have come.
I have served, my lord. But that has.
You might have misplaced. They will not misplace.
Kindly makes me.
The petitioner is Mr. Bhattacharya, learned advocate.
Yes.
Yes,
One HCM lordship, my senior Anjan Bhattacharya, he left the court for personal difficulty of paying for not to the lordship. Is the petitioner lordship?
Have you served?
Yes, lordship, already served lordship. Last occasion lordship passed the order and already served. ওই তো দাঁড়িয়ে কারো বলো আমি রেসপন্ডেন্ট petitioner.
No, contempt application have you served?
Yes, lordship. They
Very
are
good.
served. Lordship. I do not have any instruction.
When the order was passed, directing you to serve?
Lordship, the order was passed kindly. Lordship. Okay.
When the order was passed?
Lordship, kindly give me 1 minute time, Lordship. I take the date, Lordship. Date not upload, but Lordship already have direct server copy to the other side, and the
When? By which order?
but the order is not uploaded in the website, Lordship.
There is no order passed, I find.
But I already served, Lordship.
You have served without any order.
Lordship had passed an order
When?
Lordship was sitting in the courtroom 19, Lordship.
When? What is the date? There is no order passed on this.
Your God.
There is no order passed.
Already served.
Please give me the date when the order was passed. That is why I do not find any order passed directing you to serve. You have your communication letter. Where is that?
Right now, I have no commission letter. I have with me, Lordship.
The petitioner is directed to serve a copy of this content. Next.
The date, Lordship?
4 weeks.
What?
Yes, next.
Comment has joined.
All matters you are appearing, Mr. Pan.
No order has been complied with. Order passed by your lordship, not a single matter your lordship will find the order has been complied.
What can be done?
So I am also I see something is to be done by your lordship, so that the order may be complied with.
Yes.
Since 18th March 2026, Abhishek Kumar Tiwari has joined.
18th March?
2026.
A new incumbent has joined.
Abhishek Kumar Tiwari has joined.
Incumbent has joined. That is one way, but what do you say to this order? New incumbent might have joined. What is the direct purchase?
Yes.
All the matters are in process.
How long it will be under process?
Kindly adjourn it for 2 weeks.
All right. Mr. Pan, please. New incumbent has joined. Leave his.
Container number 1 and 2, they have transferred, my lord. Container number 1 and 2. 3
are
and 4 are the
appearing.
same. But I am appearing for all the containers. New incumbent has joined in place of container number 1 and 2.
1 and 2. Yes. Now, what is your
My lord,
instruction?
in this matter, my instruction is, my lord, it is.
What is this matter, Mr. Pan? What is the
my lord,
direction?
Direct purchase. The amount.
All direct purchase.
Your lordship directed to
In
pay.
this matter, the parties was agreed to a particular amount.
My lord, the amount is
That
9
to
lakh.
1 year back. Based on that, your lordship passed an order.
My lord, as per my instruction,
Kindly
my lord.
see, my lord.
My lord, kindly see.
What is the report?
Only kindly give me some time. We have placed it. A letter has been sent to the Joint Secretary to the Government of West Bengal INW Department for the fund, my lord. As soon as we get the fund, my lord, we will pay.
No, this is not acceptable. As and when the fund will be available, possibly.
As and when is a very vague
No, my
vague term. When? Please give me a specific time. I record that.
4 weeks.
4 weeks. mm, the Ms. Banerjee, learned advocate, appears for the here.
তাহলে অন্য কন্টেন্ট
Matter will appear after 4 weeks. File the affidavit and serve upon him. Yes, next.
Lordship, I am for the petitioner, my lord. That should not pass the disbursement amount within January of this year, lordship. It's been almost 1 year, my lord. No disbursement has been made, my lord.
Yes.
Lordship, in regard to this matter, to take instruction, Lordship, I do not have any instruction in this matter.
Kapoti, please give
And-
her a copy.
And copy
Otherwise-
The answering respondent is principal secretary, Lordship.
Not the respondent. Now it's the contemner. She is representing the alleged
Lordship,
contemner.
yes.
So please serve her a copy so that she can take instructions. Let a copy. None appears for the petitioner at the time of
Your Lordship, this is my contempt application, Your Lordship. Again, it's a civil division, Your Lordship.
First time?
Yes, Your Lordship. This is for the first time, Your Lordship. There was direction upon the authorities to dispose the matter as early hearing, but till date they have not taken any step, Your Lordship.
what was the order passed?
Your Lordship, at page 117, Your Lordship, the order was passed. Directing page 118, Your Lordship. It was for an early disposal, Your Lordship, but till date the authorities have not taken any step for hearing. Page page 118.
Yes, Ms. Banerjee, can you appear in this matter? This is a RERA authority. A direction was passed to dispose of these proceedings.
They have not
This has not been done.
They have not,
Uh,
not taken any steps. Copy
Mr.
has been despite of
RERA, you can represent.
Jilla Parishad. No,
RERA,
they-
West Bengal Real Estate
Real Estate.
Regulatory Authority. When have you communicated this order?
Your Lordship, it has been communicated.
What are the orders passed after that?
No orders have been passed. Your Lordship,
They fixed a date, my lord, but no
I've
order.
got-
Hearing was fixed on 9th of March.
Yeah, but nothing was done. It was not fixed. It was not done, my lord. It was nothing was done on that date.
What is the order dated 9th of March?
No order passed, man. No order passed.
Some where have you stated that no order passed on 9th of March? Which paragraph? You have not stated that.
My lord,
9th of March. There must be an order sheet. Adjourned, something must be done.
Nothing was done, my lord. My instructions that nothing was done on that date.
Please, you have to file a supplementary affidavit stating that 9th of March no order was passed. The learned None appears for the petitioner at the two one nine four na 2195. 94 টা তো read. 2195, yes. Same order, none appears, no accommodation sought for. এই ঠিক হচ্ছে না, ধ্যাৎ, কি বলছেন? আগেরটাই ছিল 338, আগেরটাই ছিল 338। None appears for the petition at the time of call. Same order, none appears. Next. None appears, service 8 weeks আগেরটা। Yes, service 8 weeks আগেরটা এটাও তাই। None appears for the petition. No accommodation has been sought for either. So right, same. 8 weeks. Yes, next.
Petitioner, Lord. Your Lordship, Lord, we are seeking leave to file a supplementary affidavit in our so-called compliance order has not been annexed. That's why, Lord, kindly.
It has been complied with?
Not complied with. That is our complaint. Lord, your Lordship directed to frame the pay scale. That has not been done, Lord, that order.
So this is appearing for the first time, contempt application.
Yes.
So you serve a copy.
We are serving, Lord, and with this supplementary affidavit.
What supplementary for what?
Lord, that reasoned order has not been annexed. We have mentioned it. By mistake, Lord, it has not been annexed.
Which paragraph you have mentioned?
9th March order.
So your prayer for revision of pay scale was not considered?
Not at all. Lord, page 14, Lord, kindly see, Lord.
But
it has been mentioned that it has been annexed, but it has not been annexed. That's why, Lord. A copy of the said orders, reasoned order.
Which page? Which page?
Page 14, paragraph 10, annexure.
Rescission order has not been annexed.
Yes. Only for that reason, Lord, supplementary evidence.
What was the direction?
Direction was, Lord, your Lordship can see your Lordship's order to.
Then they have passed a rescission order.
Lord, no, kindly see.
So they have passed an order on 9th of March. Mr.
9th
Ghosh, if you are agreed, we have to challenge that.
No, that part has not been done at all. Lord, kindly see your Lordship's direction.
Yes.
That is not page 21. Second last paragraph. Since a
Yes.
prayer for revision of pay scale has been
submitted
before the complainant, this has not been touched. Nothing, no order has been passed. That's why that so-called rescission order we want to annex.
Mr. Ghosh, Learned Senior Advocate, appeal.
There are two one
Yes.
for the petitioner, my lord. This is appearing for the first time, my lord.
First time?
First time, my lord. There was a direction upon the alleged contemners to pass a reasoned order after doing the necessary inspection.
Yes. Petitioner is directed to serve a copy of this.
The petitioner, my lord, page 18, my lord. So order passed by your lordship, my lord.
Not complied with?
Not complied with. There is mandatory direction to comply the order within 30th March by the
Compensation?
Yes, ma'am.
Yes, Ms. Banerjee, can you appear? Compensation matter, please appear. Let a copy of the contempt application be. Yes, next.
I am paying leave to correct the name of the contempt.
Leave to correct the name of the contempt.
There is spelling of the name.
Spelling mistake. Leave to correct. Yes. Yes.
2201
to correct the cost act.
2201, my lord, first time, my lord.
First time. What was the direction? National Highway.
Yes, my lord. Page number 18.
Enforcement is the DM.
Yes, ma'am.
Yes, DM. Appear. DM has changed.
No, my lord.
DM not changed. What are you saying?
No, changed. My lord, not changed, my lord.
Purva Medinipur DM has not been changed.
No, my lord.
Sure.
He
You're
wa-
sure?
He was appointed at the time of election and till date.
Thereafter also same.
Yes, my. Yes, my lord.
Krishna is directed to serve a. First time. Collector. Changed. Not changed, same. You have imputed the new incumbent. After that, you have filed the contempt application. You have not given them time to comply with that. What? No. When the new incumbent has joined. So, yes. You have to give them sufficient time to comply with that.
Kindly see, my lord. Kindly see. The collector, the position was said, might have the new person has come.
will not give them time to comply with that.
Let us
have a copy of
immediately dismiss করে দেওয়া উচিত।
the collector the contempt.
File afresh, after some time withdraw this, file afresh, give them.
আমারও তাই মনে হয়।
Already, trying to see when the order was
জজ সাহেবের
passed.
আমাকে না অ্যামিকাস কিউরি করা উচিত ছিল এই মামলায়। আমি আদার সাইডের
What is the object to enable them to comply? You have to give sufficient time.
This is the order passed on 15 January 2025. Then,
Part by limitation, you are coming after.
possibly not. Within 6 months. Within 6 months.
Petitioner is directed to serve a
দে না।
yes.
কেউ নেই ফোরে।
Who is appearing?
নেই।
মামলা করবে।
এটা করে নিতে দে। আমার ব্রিফ কোথায়? হ্যাঁ। তো তুই দিচ্ছিস কেন?
নানা পিয়াসটা লিখবেন না, তো petitioner is directed.
Portion, not even the A.
First time, Mr. Chatterjee, you are appearing.
Yes.
Contempt
না,
of
তোমার
first time.
না
Leave something from the junior advocates.
কি হলো আমাদের জন্য?
But that is exactly why I am here, Milad. Something for the junior.
কবে থেকে?
Your gown does not say so.
The gown is junior senior act. That is something for the junior.
Yes, what is this order?
Your Lordship directed mutation within 8 weeks.
Directed?
My lord,
What did I direct?
for mutation, my property in my name. The estate manager said that you did not implead me in the earlier proceedings. That's why I don't.
No appeal?
No, no appeal. No appeal. Same person. He is now the estate manager.
Estate, then you have to
to.
serve.
Yes.
Petitioner is directed to Mr. Chatterjee. Mr. Chatterjee, learned senior advocate, appearing for. It is however made clear. Yes, yes, call the next matter. Rahul. 2206.
2206 and 2207.
The arrest container complied with.
No, Lordship, not yet.
Din, 5. What do you want?
Lordship, pray for 3 weeks for submitting the complaints.
The learned advocate for the alleged contempt appeal.
I appear for the petitioner, my lord, pursuant to the last direction.
learned Additional Advocate General submitted that he had instructions that they wanted to prefer an appeal. My lord had asked them to come back with instruction. My lord, this is that case of fast track courts. Order is of 2nd August 2024. Group D employees, they are still receiving a remuneration of 8,000 rupees per month.
Now the
But
panel
they
has
did not prefer any appeal, my lord. No, at least we have not been served with any notice or any, my lord.
to serve upon the alleged contemners, otherwise, because now the panel has
It has been served. After that, they have appeared.
no the new from the new panel they have appeared. No,
No, not new panel.
now the
Yes,
you have instructions to appear.
Yes, Lordship.
Yes,
Instructed to
please
appear
take
before your-
instructions.
Yes, Lordship. In that
You have
case,
a copy of the contempt application.
No, not yet.
Serve, Miss Bhadra-
Bench clerk, my lord, the remuneration, I don't know, they have prepared.
the file is not here. It has to be found out.
Only direct them, direct me to serve upon the learner. Same matter.
You can serve a copy upon her the restoration application. File cannot be taken out now. In a different branch.
My lord, I cannot serve, my lord, the contract application or.
Restoration application you serve up.
I cannot, my lord, because the first time it was dismissed for.
All right. Let me see on the next day. Yes. Call the next matter. You are appearing. Yes.
My lord, there are two aspects in this matter. Your lordship directed to consider their representation. We have considered it, and thereafter we have to make the payment of extra remuneration. My lord, that is in process. For that,
That
we
is
need
in
some-
process.
And so far as the second part, my lord, the second part of the order, my lord.
Extra remuneration.
Extra remuneration in terms of the order dated.
Yes.
January 7th.
They have paid for some time. Early settlement is expected. That's their. Please see.
Lordship, a copy may be given.
Please give a copy. I'm adjourning it for 2 weeks. The learned advocate appearing for the heard the learned advocate for the petitioner, the learned advocate for the alleged contemners.
Lordship, Lordship, I beg to appear on behalf of the alleged contemner over here.
This is a matter where it's of pay division, not pay division, it's a fixation of the special pay of the retired
Yes,
officers.
what is the instruction?
What is the last
To
of the
place on
there was
record
a-
the decision of the meeting.
My lord.
Lordship.
Where is that?
We have it. We have it. Lordship, Lordship, on the previous occasion, we have filed one instruction, Lordship.
You said you prayed for 2 weeks' time to
Lordship,
place on record the decision
and
of the
steps,
meeting.
Lordship, there has been a letter was placed before Lordship on the previous occasion of letter dated 2nd of April 2025, Lordship.
2nd of April 2025. No, you prayed for 2 weeks' time to place on record the decision of the meeting.
Meeting,
On 1st of April
Lordship.
2026.
Yes, Your Lordship.
Where is the decision
Lordship.
of the meeting?
May I hand over, please?
Subsequently, 16th March, RPA Import Association has been directed to implement among the
if your lordship kindly takes up the letter dated 16th of subsequent to the minutes, lordship. The Indian Ports Association has been directed to.
This is your meeting. This is your minutes.
Lordship, page number 3 is
9th of February 2026.
Lordship.
Yes.
16th of March, lordship, IPA has been directed to take steps.
But where is that?
Lordship, the next page.
Later date requested the within 6 months. What happened?
Lordship, kindly takes up page 4 of that, lordship.
16th of March, yes.
16th of March. That letter of that Indian Ports Association has been directed to take up this issue, lordship. If your lordship kindly takes up paragraph 3 of that letter, lordship, of 16th March. Accordingly, all ports are requested to implement the second method within 6 months from the date of issue of this letter and consolidate the pension as per direction of the ministry issued via order so and so dated 5/2/2020.
6 months is almost, it's now coming.
Lordship,
September.
Lordship, what I am humbly beseeching your lordship is that your lordship, by an order of this contempt, which is under contempt, your lordship has directed the ministry to take a decision so that the implementation could be made effect, lordship. That implementation the ministry has
File
taken
a
a
compliance report then on the next day.
Certainly,
May I
lordship.
get an opportunity, my lord.
File a compliance report, then you will be having your chance.
We'll be enclosing these documents only in the affidavit of
My lord,
compliance. lordship.
that's what I'm contradicting here. They are coming with another minutes, which is perhaps it's not to the
Let him file the
instruction.
compliance report, then I will see.
We'll annex everything, lordship. for that.
So I appear for the petitioner.
Yes. What happened?
This is the 4th or 5th time I have served notice. So against Howrah Municipal Corporation, order passed as early as in March 2015 with regard to payment of retirement benefits of an assistant engineer. Even the portion which they had admitted before this court, that amount also not been paid. No appeal has been preferred.
Now I'm making it not today because now I cannot issue a
The affidavit service it will be kept to
take it back. I'm only making it not today. Yes, not today, next.
affidavit service.
2211 देखी first time की ना देख not today करेंगे. Yes, next.
मतलब 2212 and मतलब 2213.
Yes. You are appearing.
Lordship, but this matter is led by the Nilanjan Bhattacharya Senior Standing Counsel, Lordship.
Yes.
Due to
You have instructions to appear. You
Yes,
have a contempt application.
Yes,
Mr.
I've served,
Lordship,
long
Lordship.
back.
No,
Lordship.
that's earlier time.
No.
Even last time, after the change of panel, I have served her.
Yes, Lordship.
All right. What is your instruction?
Lordship, we don't have instruction till yet, Lordship, because due to illness of my senior, Lordship, we don't have to connect with the competent authority, Lordship.
Right. Because this is pending for a long time. I'm keeping it after 2 weeks.
Ask them to file a compliance report at least.
An accommodation Separate order, same order. Next.
Deeply order.
Lord, we have for the petitioners, Lord, your lordship, Lord, dated 11 February 2026 has been violated, we filed in a contempt application. While Lord extending the interim order, your lordship also gave direction to take instruction. Lord, they have filed an affidavit in opposition. Lord, thereafter, in view of, I think, Lord, in view of change of panel, nobody is appearing.
Now,
Lord, we have also ready our
this is a land matter.
land matter.
Yes, you have instructions to appear.
No, not yet, Lordship.
Not yet. Please appear in this matter.
Lord, our reply may be kept with the record. It is ready.
Reply to what? Contempt application?
Yes.
Affidavit in reply filed by
Next two matters are assigned matters before your lordship, pending long back. They took time. Kindly fix up any.
2014.
next. I will be fixing this group, Mr. Pan. Today I have taken up the content. Let me see. I have to fix that.
Another day, my lord, for this.
Those motions are also pending. I have to adjust all groups.
Yes, yes.
My lord,
As
I will consider that because one group I could touch, the other groups I will.
My lord, as directed, may I file the list of dates and judgment? That matter, my lord, that day before
Your
yesterday.
Lordship, I'm appealing for the respondent. I'm also filing.
What are you?
Yes.
Judgments you have already cited.
Yes, but with the page numbers, Your Lordship, have
Page numbers. You are not citing any new judgment.
No, no.
My lord, extremely urgent. My lord, extremely urgent issue, my lord, needs to be brought to your lordship's notice, my lord. Your lordship has yesterday, my lord, passed an ex parte order, my lord, staying up proceedings initiated by the learned estate officer, my lord. We were not on caveat, my lord. We would have otherwise brought to your notice that proceedings has already been, my lord, completed. Final order has been passed, my lord. So, my lord, that issue needs to be brought to your notice, my lord. I was only
Take out an application.
If it could be, my lord, to be mentioned, we will show, my lord.
Cannot be done. To be mentioned, it cannot be done. Take out an application.
Very well.
I will record that.
Prior to rising, item number 52 of the days list. I am trying utmost, but could not get.
52.
Yes, yes, okay.
Today I have completed up to 41. So it's expected to be taken up tomorrow.
Kindly to consider to some extent,
right.
otherwise
My lord.
the trial court is approaching.
All right.
My lord, my matter is listed today also at 63. My lord, I am trying for the last couple of days. My lord, I am humbly requesting, my lord, kindly take up the matter tomorrow. I am in extreme hardship,
Let
madam.
me see. I have reached up to
As a,
41.
as a assignment,
See,
I have
now
no.
Only 5 minutes.
I can
left,
understand,
not
my lord.
five.
I can understand, my lord. I can only request, my lord. I have also filed a can today, my lord, for.
Right. That will be taken up. Unduly putting pressure upon the court.
No, I'm not.
Please see the clock.
I have already seen, my lord. It's all
Unfortunate, sir.
grateful, my lord.